Okay, and you guys are good to go. All loss is going to be at 458. Good luck, everyone. Have a good round.
Thank you. Okay, we will call the case and we will have pretrial issues. Is there anything that the plaintiff would like to address before we get to opening statements?
Yes, Your Honor. First, may we make appearances?
Of course.
My name is Patrick Arnold, and along with my co-counsel Madeline Turk and Matthew Moorhead, we represent the plaintiff in today's case. Also, Your Honor, may we assume for Zoom purposes that you have seen and you have access to the bench book, including all the relevant case law and to rules of evidence and relevant case documents?
Yes, I have the bench book right here. So if you need me to refer to something, just let me know and it'll just take me a second to pull it up. But I have access to everything.
Great. Our next thing, we would now like to invoke Rule 615, the constructive sequestration of all witnesses, barring a party representative. The plaintiff does not have a party representative in today's case.
Okay. Does the defense?
The defense does not, Your Honor.
Okay. All right. That'll be granted.
Next, Your Honor, we'd like to ask about your preferences for how to handle different Zoom functionalities. Would you like us to ask permission to share our screens for all exhibits, demonstratives, or affidavits?
You don't need to ask permission. Just go ahead and do it. Maybe let the record reflect that you're doing it, just so that it's clear what you're doing. And whatever you decide to do, just whoever follows that, just follow suit, and let's try to keep it uniform.
Yes, Your Honor. Would Your Honor like us to constructively bar the jury from seeing any exhibits until they are entered into evidence? So, for example, if an exhibit were to come up on the screen that has not been admitted into evidence, may we assume that it is constructively barred from the eyes of the jury until entered into evidence?
Yeah, we'll just treat it as if it was normal, where they can't see it until it's been published.
Great. And the last thing, Your Honor, is that the plaintiff would like to direct your attention to Stipulation 3, which reads that Exhibits 1 through 10 have already been admitted into evidence, and therefore they're able to be used or referred to without objection at any time by either party, including in opening and closing statements.
Okay, so you're offering those into evidence at this time?
Yes, Your Honor, per Stipulation 3.
Okay, and defense, you concur?
Yes, Your Honor.
Okay, so exhibits 1 through 10 will be received and they can be referred to at any point.
Yes, Your Honor. And with that, the plaintiff is ready to proceed.
Okay, defense?
Good afternoon, Your Honor. May we make introductions before the court?
You may.
My name is Erica Daly, and I will be the defense closing attorney in today's case.
All right.
Your Honor, my name is Kylie Berube, and I will be the defense opener in today's case.
All right.
And my name is Elena Moore, and I will be the defense middle attorney in today's case.
All right. Good afternoon to all. And do you have any additional pretrial matters that you'd like to attend to?
Yes, the only thing we would like to ask is, since we are in a virtual environment, we would like to ask the court's permission to remain seated with our camera angles set throughout the remainder of trial today.
Yes, seated versus standing is it's to your discretion.
Thank you, Your Honor. The defense is ready to proceed.
Okay, then I'll hear opening statements from the plaintiff first.
Yes, Your Honor. May I proceed?
You may.
May it please the court, opposing counsel, members of the jury. When a winery has multiple FDA violations over the course of 2 years, it's no surprise that something is destined to go wrong. On the evening of June 7th, 2019, Casey Soto and Genesis Petrillo were having their rehearsal dinner at Peony Estates before their wedding planned for June 8th. Casey's parent, Harper Martini, presented Genesis with a bottle of 2019 Cara wine during the rehearsal dinner. After drinking the wine, Genesis died, and a toxicology report revealed that there were pesticides in Genesis's system. These pesticides in the bottle of wine were as a result of the poor health and safety practices of Peony Estates and the defendant's failure to enforce necessary health statutes to protect those consuming their product. Now, to hold the defendant accountable for the death of Genesis Petrillo, the plaintiff will prove by a preponderance of the evidence that the defendant is guilty of negligence per se. This means that after hearing all of the elements in today's case, you all, as reasonable people, can come to the conclusion that Peony Estates was negligent in their handling of pesticides and that this negligence caused the death of Genesis Petrillo. According to case law Wando v. Cornforth, negligence per se requires us to prove four things. First is that the defendant violated a statute. Second is that the statute in question is a safety statute, which is not in question given that this is a safety statute 12100. Third is that the defendant's actions caused the type of harm that this statute was intended to prevent. And fourth is that the plaintiff was a member of the statute's protected class, which is also not in question given that Genesis Petrillo was intended to be protected. This leaves us with two obligations to prove to the court today. First is that the defendant violated Midlands Building Code section 12100, which requires facilities where products are kept to be kept sanitary with preventative measures against contamination, effective storage of pesticides, and safe and hygienic practices meant to protect its consumers. Second is that the defendant acted in a way that allowed pesticides to get into that bottle of 2019 Cara wine, ultimately causing Genesis's death. To prove our burden today, we will call three witnesses. First, you'll hear from Lonnie Paris, a scientific journalist who investigated Peony Estates over the course of 3 years. In his investigation, he observed the bottle of 2019 Cara wine on multiple occasions in direct proximity to empty pesticide containers. Mr. Paris then discovered that there were pesticides inside the bottle of 2019 Cara wine, and that those pesticides matched the exact same pesticides that Peony Estates uses on their grapes. Lastly, he was able to verify that Genesis Petrillo died of pesticide poisoning by obtaining her death certificate. Second, you'll hear from Danny Francasio, the owner of Rosie and Pedro, another winery in the valley. The defendant contacted Ms. Francasio because they did not know how to safely handle pesticides and ensure their employees followed safe procedures so that no wine was contaminated. And lastly, you'll hear from Riley Adkins O'Keefe, the FDA inspector who performed multiple inspections on Peony Estates. In the year preceding Genesis's death, Inspector O'Keefe found that Peony Estates had been storing and using pesticides using unsafe methods. In a visit just a month before the wedding, he found that not only were they still storing pesticides in unsafe ways, but also that their employees weren't aware of the necessary health statutes. Finally, just days before the wedding, O'Keefe found a single bottle of 2019 Cara wine in the bottling area, right next to where the pesticides were previously stored. Then, on June 7th, 2019, Harper Martini gifted that same bottle of 2019 Cara wine to Genesis Petrillo. Genesis then drank that wine, and at 9:27 a.m. on the morning of her wedding, she was pronounced dead due to pesticide poisoning and contaminated wine. The defense will be pushing a narrative of alternative causes of death and emotional pulls. We ask you to look to the concrete evidence provided in today's trial to come to the logical and reasonable conclusion that Peony Estates negligently handled pesticides and disregarded safety statutes intended to protect their consumers. As a result, it ended in the tragic death of Genesis Petrillo the night of her wedding. Because of this, at the end of the trial, my co-counsel, Maddie Turk, will ask you to find Harper Martini and Peony Estates liable for negligence per se. Thank you.
Your Honor, if I may proceed.
Yes, you may proceed with opening statement. Thank you.
Your Honor, opposing counsel, members of the jury, may it please the court. The plaintiff's counsel just came before you and they told you a story, but their story will leave you with too many questions and not enough answers. Peony Estates is a local boutique winery and bed and breakfast that was started by Harper Martini. And Peony Estates is located along a river in the winemaking region of Midlands. The winery had a pest problem because of their location. They initially tried to solve this by using organic pesticides, but those just didn't work. the winery had to start using chemical pesticides, which require much more safety measures for handling and spraying. But Harper Martini was confident in her staff, so much so that the winery owner decided to host her own daughter's wedding at Peony Estates. However, this wedding never took place, as the morning of the event, after a night of celebration and heavy drinking, Casey Soto, Harper Martini's daughter, Casey's soon-to-be wife, Genesis Petrillo, tragically died in the hospital that morning. The plaintiff has told you about how Peony Estates was careless with their pesticide use, and because of this, Genesis Petrillo died by ingesting pesticides from a contaminated bottle of wine gifted to her by the winery owner. And for this reason, the plaintiff has accused Peony Estates of negligence per se. And to prove this to you, the plaintiff has to show that Peony Estates failed to put sufficient safety precautions in place to protect against pesticide contamination. They must also prove that as a result of following proper procedure, the bottle of wine gifted to Genesis Petrillo was contaminated with pesticides, and as a result of pesticide poisoning from that bottle of wine, Genesis Petrillo died. Now, the plaintiff has to prove this by a preponderance of the evidence. That means that you would have to believe that one out of hundreds of bottles of wine produced by Peony Estates was contaminated. And you would also have to believe that that one bottle just happened to be the one gifted to Genesis Petrillo. But this chain of events raises too many questions about what happened to Genesis and doesn't provide enough answers. We will call 3 witnesses today that will raise some questions that the plaintiff doesn't want you to ask. First, we will call Dr. Cannon. We expect his testimony to pose this question: how exactly did Genesis Petrillo die? He will tell you about different possible reasons for Genesis' death and how we still don't know the exact reason for Genesis passing. Next, you will hear from Austin Lewis, one of the main staff members at Peony Estates. Mr. Lewis will explain Peony's procedures for proper pesticide usage and how he ensured his staff followed these procedures. We expect this testimony to leave you with this question: how did one bottle out of hundreds produced at Peony Estates over the years become contaminated with pesticides? Finally, you'll hear from Blair Osborne, an event planner who organized many events at Peony Estates over the years. She can speak to the cleanliness of Peony Estates and the commitment that Harper and her staff had to ensuring the safety of their clients. And we expect her testimony to leave you with this question: how is it possible after so many years without a single incident could Harper's own future daughter-in-law become poisoned by pesticides? At the end of today's trial, my co-counsel Erica Daly will come before you and ask if you really believe that the plaintiff's story is still more likely than not, or did the plaintiff leave you with too many questions and not enough answers? Thank you.
Thank you to the defense and to the plaintiff for your opening statements. Plaintiff, would you please call your first witness whenever you're ready?
Yes, Your Honor. The plaintiff will be calling Lonnie Paris to the stand.
Okay, and you may proceed whenever you're ready.
Mr. Paris, are you there?
Yes.
All right. Please state your name for the court, spelling the last for the record.
Lonnie Paris, Paras.
Mr. Paris, what's your background?
Well, I'm a journalist and one of the best ones out there. I have my bachelor's from Northwestern in journalism and environmental science, and my master's degree from video and science journalism. I've been an investigative journalist for the past 15 years, and they haven't stopped me yet, and they ain't gonna.
And how'd you get involved in today's case?
It was back in 2016. I received a tip about a winery's use of pesticides. Little did I know that it would lead me to a career-defining story, chasing down leads on pesticide misuse, poisonings, and an ultimately tragic ending. My story was on the now famous Peony Estates.
How confident are you in your story's accuracy?
Very. I hold my work to the highest standards and would never release a story I couldn't confirm with impeccable sources.
So what were your sources for this story?
Over the course of my 2-year investigation into Peony Estates, I witnessed discarded pesticide cans in back rooms, obtained a death certificate from a hospital, had pesticides in bottles of wine chemically tested, and obtained emails from senior staff at Peony Estates. It took me years of my life, but that's the price I'm willing to pay for the truth.
All right, so I'd like you to take us through your story, starting with the pesticides. How did you begin your investigation?
Well, the bulk of my investigation came from my firsthand observations. I would join one of the winery tours and then slip out to poke around behind the scenes of the estates. Over the years, I became familiar with Peony's employees, practices, and facilities like their private offices and bottling areas.
And how would you describe Peony's facilities?
Well, sometimes they looked fairly tidy, but for the most part, the back rooms in the bottling area were littered with discarded aluminum pesticide cans. They were all the same brand called Bug Off. I also explored Mr. Martini's office. He was the owner of the estate. And in there, I found my first big break, a private all-staff memo.
And would you recognize this memo if I showed it to you today?
I would.
All right, Your Honor, permission for co-counsel to display Exhibit 12.
You may.
Give us just one moment. I apologize for the difficulties. Give us just one moment. All right, there we go. So, Mr. Paris, what is this document? Mr. Paris, I believe you're muted.
This is a copy of the memo that I had found in Mr. Martini's room when I was first investigating there.
And how do you recognize it as such?
Well, it has the date July 1st, 2018, and it's addressed to all of the employees at Peony Estates.
Is this a fair and accurate copy?
It appears to be, yes.
And does it appear to be modified in any way?
No.
The plaintiff now enters Exhibit 12 into evidence.
Would the defense like to be heard?
Yes, Your Honor, I object to hearsay.
Plaintiff, care to respond?
Hearsay on what terms?
Your Honor, just documents being used for the truth of the matter asserted and the contents of the memo.
Okay, I understand the objection. Do you have an exception, or is it not being offered for the truth?
Per Rule 801 D2D, it's admissible because it's a statement from the party's employee.
Okay, defense, would you like to be heard?
Your Honor, would defense plaintiff counsel clarify which party opponent is using this document?
I believe that they cited the subsection D, so a statement by a employee within the scope of their business, that it's a party opponent.
Your Honor, then I would ask for a limiting instruction solely on that subsection.
It gets to be offered for the truth under party opponent, so I'm going to deny your request for a limiting instruction, and it will be accepted and can be argued for the truth of the matter. So objections overruled.
Okay, thank you, Your Honor. May I continue?
You may.
So, Mr. Paris, how does this memo add to your story about pesticide usage at Peony Estates?
It's written by a Mr. Lewis, who's labeled as the head winemaker at Peony, so I couldn't ask for a better source for my story. He states that there had been a recent insect infestation that was seriously eating into the estate's profits that called for immediate action.
Did Mr. Lewis suggest any immediate action?
He did. He writes to the employees in this memo, "We need each and every one of you to prepare the entirety of Peony Estates for an imminent pesticide spraying. We need to do this quickly and cheaply. Nothing else matters."
All right, I'd like to continue. Did you learn anything about the winemaking process during your investigation?
Like I said, I took that tour twice monthly, but I did discover importantly that Peony Estates only produces wines with grapes from the year prior. So 2018 wine was made with 2017 grapes, 2017 wines with 2016 grapes, and so on.
And why was that important to your story?
Well, I was concerned about the 2019 wines that would be produced from the 2018 grapes. I had evidence that pesticides were in use throughout 2018. Each month I visited, I saw new and old pesticide cans scattered about the back rooms. And that email from the head winemaker said that they were spraying the entirety of the premises. I decided to prolong my investigation into 2019 to track those potentially contaminated bottles of wine.
Can you describe your next notable visit to Peony Estates?
Yes, it was June 7th, and the owner's son was getting married, and I had the perfect disguise. I was a caterer. After I snuck a few desserts off a tray, I slipped out of the dinner to do some digging in the back rooms while everyone was distracted. I apologize.
And did you find anything in the back rooms?
Well, the most obvious thing to me was this single bottle of wine on a shelf, all on its own. It stuck out like a sore thumb, and next to it was an empty bottle of pesticides.
So besides that, what made it stick out to you so much?
Well, it was labeled 2019 Cara. It was the only bottle like it that I had seen the entire night, and it was one of the newest wines they had. And it was sitting all by itself across from an empty pesticide can in the bottling station. Between that and the pesticide use in 2018, well, I tried to keep track of the bottle as best I could.
So after you found the 2019 Cara, what did you do?
Well, as I was taking a mental note, I saw the owner, Mr. Martini, taking that bottle of 2019 Cara off the shelf and carrying it away. I decided to go into the event hall to follow, but on my way out, I bottled a sample from the pesticide can so I could send it to a lab for analysis.
And that night, did you see anyone drink that bottle of Cara?
Well, Mr. Martini hand-delivered the bottle to the bride-to-be, and I saw her pouring and drinking the whole night, and as far as I know, there wasn't a full bottle of wine left by the end of the night.
And did you visit the estates the next day?
I did. I came back the next morning and something was wrong when I got there. People were talking about ambulances at 3 a.m. My best hunch was that someone was in the hospital, so I rushed over.
Did you find anything at the hospital?
Unfortunately, yes. The attending doctor treating Genesis was telling a few wedding guests that Miss Petrillo had been killed by pesticides, that she was poisoned. As a journalist, though, I needed a better verifiable source, so I obtained Genesis Petrillo's death certificate from a trusted source.
Would you recognize a copy of that death certificate?
I would.
Okay. So permission for co-counsel to display Exhibit 7, which was entered into evidence in pretrial per stipulation 3.
Yes, that permission is granted.
Okay. So what is this document, Mr. Parras?
This is the certificate of death of Miss Genesis Petrillo.
And how do you recognize it as such?
It has the signature of the chief emergency physician at the bottom.
Is it a fair and accurate copy?
Yes.
And does it appear to be modified in any way?
It does not, no.
Okay. The plaintiff now enters Exhibit 7 into evidence.
Well, I believe it's already in evidence, so I don't believe you need to offer it at this time. So it just speaks for itself.
Okay. My apologies.
No problem.
Let us continue then. So, Mr. Parras, how did this death certificate help develop your investigation?
Well, this certificate clearly states the causes of Miss Petrillo's death as concluded by the chief emergency physician at Midlands.
And what did the chief physician say killed Miss Petrillo?
It states that Miss Petrillo died of respiratory failure caused by pesticide poisoning. The method of poisoning is identified as ingestion of isofenfos, a chemical in the pesticide, likely through contaminated wine.
Is there anything else in the document that was relevant to your story?
Yes, the doctor also wrote the following summary. Patient attended a wedding where the patient ingested the organophosphate pesticide isofenfos at lethal doses, along with alcohol. The most likely source of poisoning is the wine the patient ingested with dinner.
So at this point, did you feel ready to publish your story on Peony Estates pesticide usage?
Well, because of the reports on how Ms. Petrillo died, it was clear that this story had gained more weight than just another environmental interest story. People's lives were at stake. Even with the memo, the certificate, and my firsthand observations of pesticide use, I looked for more evidence to confirm what poisoned Ms. Petrillo.
Did you find any more evidence?
Yes, after her death, police retrieved a sample from the 2019 Cara wine gifted to her, and I had a sample from the pesticide. If the wine was contaminated, we could expect to see high levels of the pesticide chemicals in the wine sample through a lab test.
Did you end up obtaining those test reports?
I did. I received them from an employee at the lab who I kept in contact with during the investigation.
And would you recognize a copy of these reports if I were to show them to you today?
I would.
Permission for co-counsel to display exhibits 10 and 11, which were entered into evidence during pretrial per stipulations 3 and 4.
My understanding is that exhibits 1 through 10 were admitted, but not exhibit 11. Is that something that, am I correct on that, or am I wrong?
Your Honor, we can enter exhibit 11 into evidence independently if need be.
Okay, well, if you want to have the witness discuss information on it, then I would prefer that you admit it into evidence first.
Okay. Okay. Then do I have permission for co-counsel to display exhibits 10 and 11?
You do.
Okay. All right. So Mr. Paris, what is this document, or what are these documents?
These are laboratory analysis of the 2 different samples from the bottle of Caro wine and the pesticide.
And how do you recognize them as such?
They have the name of the laboratory and the client who submitted the samples at the top.
Is it a fair and accurate copy?
It appears to be, yes.
Do they appear to be modified in any way?
They do not.
Okay. The plaintiff now enters exhibit 11 into evidence.
Any objection regarding the admission of exhibit 11?
No objection, Your Honor. Pursuant to stipulation 4, if Lonnie Paris is called at trial, then exhibit 11 is pre-admitted into evidence.
Okay, then it'll be accepted and you may proceed.
Okay. Mr. Paris, can you describe to the court what these 2 reports contain?
Yep, very simply, it's the police report, the police submitted sample from the Caro wine and my sample of the pesticides the night that Ms. Petrillo died.
And what are the results of that lab analysis?
Well, the lab was searching for irregular levels of pesticide chemicals. The can of pesticide had tested high for levels of isofenphos, which makes sense because that's a main ingredient in the pesticide.
And what about the 2019 Caro?
Well, the wine bottle had only one type of pesticide flagged as high. It was isofenphos, the exact same chemical as in the pesticide that Peony Estates had been used in 2018 and left in the bottling station in 2019.
So, Mr. Paris, you authored a comprehensive piece on the story of Peony Estates' pesticide usage and Ms. Petrillo's death. How confident are you in your sources?
Extremely. I witnessed discarded pesticides in back rooms, obtained a death certificate from the hospital that treated Genesis, had Peony's pesticides and the 2019 Caro chemically tested, and obtained emails from senior staff at Peony Estates. I wouldn't have run the story if I couldn't confirm it 3 times over.
So after investigating Peony Estates for years, how did you conclude your story?
Look, at the end of the day, I'm a journalist with the job to find out the truth. I have evidence that there were pesticides in the wine that Genesis drank the night before she died. Her death certificate states that she died from pesticide poisoning, the exact same pesticides that Peony Estates was leaving next to their wine cellars for at least 2 years. I leave my readers to connect the dots.
No further questions, Your Honor.
All right, defense, you can cross-examine whenever you're ready.
Yes, Your Honor. Good afternoon, Mr. Paris.
Good afternoon.
Now, Mr. Paris, your career is at stake today, isn't it?
Could you explain what you mean by that?
Well, your testimony in court today determines whether or not you can get a job.
Objection, Your Honor, lack of foundation.
Your Honor, I'm simply asking Mr. Paris a question that he is free to answer yes or no to, or to give an explanation of.
Can the plaintiff, can you explain what foundation you believe is lacking?
They have not set up the foundation that their job is at risk, nor explain the scenarios that lead it up to that.
Well, if he disagrees, and then he can disagree, I'm going to overrule the objection and allow the question to stand and ask the witness to answer it.
Mr. Paris, would you like me to repeat the question?
Yes, please.
Your testimony in court today determines whether or not you can get a job.
Well, I mean, in the sense that I'm a journalist and I'll be writing about this trial extensively, then yes, it's part of my job to report on this trial. Absolutely.
I want to talk to you about something specific. The editor-in-chief of TBD magazine approached you with a position.
Yes, that's correct. I think that was after I published this story on Peony Estates' misuse of pesticides, and they respected the hard work that went into that investigation.
It was actually when you started covering Peony Estates, isn't that correct?
That's entirely right. It was of huge interest to the citizens of Midlands.
And the editor told you that he wanted to see more of a story before he made you an offer.
I think he wanted me to report as best as I could on this trial that had taken so much importance in Midlands.
Is that a yes? He told you he wanted to see more of a story before he made you an offer?
He wanted to see more of my responsible coverage, absolutely.
In fact, he suggested to you that you should write a story on your experience testifying today.
As the chief journalist, right, the person who's responsible for how Midlands knows about Peony Estate's misuse of pesticides, he wanted me to comment on what I'm testifying today, absolutely.
And if he likes the story you write, he will consider you for a full-time investigative journalist position.
Look, every good journalist says their job is to speak truth to power, and I will do that regardless of what other job offers I have out there. I've lost jobs over investigations before, and I'm willing to do it again to find the truth.
Is that a yes to my question, Mr. Paris?
Yes, it is.
Let's talk about this story. You received a tip about Peony Estates back in 2016.
I did, and I didn't think it had much merit, so I put it on the back burner for a few years.
Let's talk about that. Danny Francasio put in that tip.
Right. Danny Francasio is an owner of a winery down the road from Peony Estates. And as an investigative journalist, I often get these tips from business rivals. They usually have not much merit, so I'd ignored it at first.
Right. You didn't take it seriously.
Like I said, usually these business rivals don't have any merit. And from what I could tell in 2016, there wasn't much there.
In fact, you hung up on Mr. Francasio when he called it in.
I guess so, yeah.
But you decided to write about it in 2018.
Well, I wouldn't say decided. There was enough evidence that merited a further investigation. And at the end of the day, I'm glad I investigated because I found the misuse of pesticide at Peony Estates.
You decided to start working back on this when you were working as a freelance investigator.
Right. As a freelance journalist, I kept a blog on the side. I wanted to keep my writing skills sharp. I realized that this is something in the backlog that might have more merit now that I've given it time to breathe.
Right. You were trying to get back into the business.
I needed something to write about, and I had a tip that was uninvestigated.
Let's talk about what you found in 2018.
Please.
You went to Peony Estate. Oh, I'm sorry. Did you have something further, Mr. Paris?
That's all.
Okay. Let's talk about what you found in 2018. You went to Peony Estates to look around.
Yes, like I said, my first visit there was to case the estates. In case I wanted to do any further investigating, I wanted to know where the entries and exits were, where they would keep their documents.
And you went on several winery tours to gather this information.
Like I said, if I'm going to report responsibly on something, I need to be an expert on it.
The first tour you went on was on July 13th, 2018.
That was right. Yep.
Then you started going twice a month.
I did.
Each time in disguise.
Yep.
You even snuck into an employees only door.
Like I said, the truth can't hide from me.
You snuck into the bottling area.
Absolutely. If Peony Estates had nothing to hide, they had nothing to fear from me poking around.
In fact, you were eventually banned from Peony Estates.
They not so politely asked me to return, yes, and that's when I decided to keep digging, and I'm glad I did.
That was on May 8th, 2019.
Correct, yeah.
And that day, before you left, you noted that the Peony Estates kitchen was spotless.
Like I said previously, for the most part, a lot of those aluminum cans of pesticides were littering the back rooms. Every once in a while, I would turn up, and for some reason, the kitchen would be spotless.
Is that a yes to my question, Mr. Paris? On the day of May 8th, 2019, you said that the Peony Estates kitchen was spotless.
Yeah, on that one specific day, yes.
Now I want to talk about something you said on direct examination. You noticed that there was a 2019 Cara wine bottle.
Right, in the back rooms the night of that rehearsal dinner, I think it was.
And you know that a Cara wine bottle was gifted from Harper Martini to Genesis Petrillo at the rehearsal dinner.
Yeah, like I said, the owner of the winery took that bottle of 2019 Cara and delivered it to Genesis Petrillo, correct?
But Mr. Paris, you don't know that that's the same bottle of 2019 Cara wine, do you?
Like I said, it was the only bottle like it that I had seen the entire night. If there was another bottle of Cara, I couldn't tell you definitively, but that was the only bottle I saw.
Mr. Paris, you weren't tracking the bottle from the time you saw it to the time it landed in the hands of Harper Martini, did you?
I did my best to, but Peony Estates employees got in my way.
So you can't know for certain that that was the same bottle.
No.
Thank you, Your Honor. I have no further questions for this witness.
All right. Thank you, Ms. Daly. Is there any redirect?
No, Your Honor.
Okay. Witness is excused. Thank you for your testimony. And when the plaintiff is ready, you can call your next witness.
Yes, Your Honor. The plaintiff would like to call Danny Francasio to the stand.
All right. Whenever the witness is ready, you may begin. Thank you.
Please state your name for the court, spelling the last.
Hello, my name is Danny Francasio. Francasio spelled Francazio.
Why don't you tell me a bit about yourself, Danny?
I was practically born in a vineyard and raised by the grapes. I remember stomping grapes in my youth. I consider myself to be quite the cork dork. I love wine, and quite fittingly, I proudly own and operate Rosie and Pedro Winery.
Where is your business located?
It was fate, really, where my winery ended up being located. I went on a cross-country road trip, and as I was passing through Midlands, I stumbled upon a winery, and I felt the grape gods calling me to purchase it. So I now operate what I'd like to call the Bordeaux of Midlands, and I have for the last 15 years.
Is running a winery difficult?
Well, the grape gods have blessed me with exceptional talent and skill when it comes to the wine business. However, there certainly are a lot of moving parts. You have to manage the land, process the grapes, comply with the health code, and most importantly, make sure your wine is stored properly, safely, and away from pests.
Have you ever dealt with pests before?
On occasion. Honestly, that's just part of the business, but the true test of a good vintner, that's a winemaker, is how you deal with the pests.
Well, how do you deal with pests then?
Honestly, taking care of those pesky bugs is pretty complicated. You have to use some sort of pesticide, but ultimately that can end up being worse than the pests themselves, so you do have to take a lot of steps to make sure that everything is done safely.
Could you tell me a bit about the steps you take at your winery?
Well, first, we store our pesticides in a garage far away from where we keep the wine. And before using any pesticides, we make sure our barrels are properly sealed and properly stored so that there's no cross. And mind you, this process.
Do we have a freeze up?
Yes. Is it
All right,
working?
Ms. Francasio, can you repeat that answer? There was a freeze up that at least I experienced there.
Yes, of course.
Sorry
Can you
about
hear
that.
me now?
Yes.
So first off, we store our pesticides in a garage that's far away from where we keep the wine. And before using any pesticides, we make sure our barrels are properly sealed and properly stored so that there's no issues of cross-contamination. And this isn't just a process that we follow at Rosie and Pedro. It is the law and should be followed at all wineries.
Now, is Rosie and Pedro the only winery in the area?
No, it is not. A couple miles away in this swamp, there's a winery called Peony Estates.
Do you know anything about Peony Estates?
Well, the owner, Harper Martini, used to be one of my little cellar rats. Don't worry, that's just what we winemakers call our cellar workers. And anyway, Harper left my winery to open Peony Estates, but she still constantly asks me for advice about how to run her winery. So I do know about her winery.
She asks you for advice?
Yes, she always seems to be asking me about how to fix problems, especially when it comes to pests.
Objection, Your Honor. As to relevance, if I may be heard.
Yes, you may.
Your Honor, anything about Harper Martini asking Danny Francasio about how to run the winery and to conduct pesticide operations goes to the knowledge of Harper Martini as to the statute, and that's not relevant in today's case, as negligence per se charge has nothing to do with knowledge. It has only to do with whether or not the statute was violated.
Okay,
Your Honor, if I may.
I'll hear from the plaintiff.
Yes, Your Honor, this is highly relevant because what is at question today is whether or not the steps that must be taken in order to ensure safety were in fact taken. Harper's knowledge of those steps and what she must do and whether or not she has the capability to follow those regulations is highly relevant to this case today. And since Harper Martini is the owner of Peony Estates and acting within her capacity as that owner, it is incredibly relevant.
Your Honor, if I may respond.
You may.
Your Honor, Danny Francasio has never even, will go on to proffer, if I may, has never stepped foot at Peony Estates, does not know whether or not Harper Martini followed these guidelines, and Harper Martini simply asking Francasio about them only goes to show her knowledge of the statute and of these regulations and whether or not she knew the proper procedure. But Danny Francasio cannot testify as to whether or not she actually conducted these procedures. That would be relevant. However, discussing whether or not Harper knew about those procedures is not relevant to the claim in today's case.
I'll hear from the plaintiff one last time.
Yes, Your Honor. This is also being laid as foundation in order to, if I may make an offer of proof.
You may.
We are using Harper's questioning and asking Danny Francasio for advice in order to lay the foundation for a set of email exchanges that was exchanged between Harper Martini and Danny Francasio, where she is asking Danny and informing Danny about problems that she is having with pests. Problems with pests and what she knows how to do with them and what she is and is not doing is highly relevant.
Based on that offer of proof, I'm going to go ahead and overrule the objection and let you make that connection.
Yes, Your Honor.
All right.
So she asks for advice?
She does. As I was saying before, Harper has emailed me on multiple occasions asking me about how to get rid of bugs at her winery.
Would you recognize these emails if I was to show you in court today?
Yes, I would.
Your Honor, my co-counsel will now display exhibits 13, 14, and 17 on the screen.
Okay.
I suppose we'll start with 13 and then move on to 14 and 17.
Very well.
So, Ms. Francasio, can you please identify what this is?
Yes, this is an email that was exchanged between me and Harper Martini.
And how do you recognize it as such?
I see my email address as well as the email address that I know to belong to Harper.
And is it a fair and accurate copy?
Yes, it is.
I ask my co-counsel to now display 14 and 17. Now, how do you recognize, or just 14 for now, how do you recognize this email as such?
Again, I see my email address as well as Harper's email address on the document.
And is this also a fair and accurate copy?
Yes, it is.
Okay, and then finally, exhibit 17.
You will see the same email address again listed, both mine and Harper's, and that is how I recognize that document.
And is it a fair and accurate copy?
It is.
The plaintiff now offers exhibits 13, 14, and 17 into evidence.
Are there any objections?
Yes, Your Honor, I would object to Harper Martini's statements as, again, relevance. I would ask that any statements about requesting help and requesting to understand the law or advice be constructively redacted. Anything about the pest problems or the presence of problems would be relevant, but again, the knowledge of the statute and the knowledge of advice to follow those statutes is not relevant. And furthermore, I would object to the statements of Danny Francasio in these emails as hearsay.
Okay, let's take those one at a time. First, the relevance to Martini's statements.
Yes, Your Honor. Once again, these are highly relevant because knowledge of a statute and of how to handle pests is an important precursor to the ability to take correct action. And that is what is a question in court today, is whether or not Harper Martini and Peony Estates took the necessary action in order to get rid of pests and keep their winery safe. Knowledge is a vital precursor in order to the ability to take the correct action needed. Any knowledge of Harper or lack thereof is therefore highly relevant, because without the knowledge of how to deal with pests, she has no ability in order to correctly deal with pests and pesticide use. And therefore, since that is what is at question today, it is highly relevant.
Okay, I'm going to overrule the relevance objection. Now let's address the hearsay objection.
Yes, Your Honor. According to International House of Waffles versus America's Best Cookie, a witness's own statements are hearsay, and therefore the plaintiff is willing to constructively redact all statements made by Danny Francasio, as long as Harper Martini's statements are admitted under party opponent rule 403D2D.
Okay, we'll have those constructively redacted, and it'll just be Martini's statements that are admitted.
Yes, Your Honor.
All right.
So when was the first time that Harper contacted you?
She first emailed me on August 26th, 2016. Excuse me, 2016.
And what was that email about?
Harper said she was having a ton of trouble with pests in her cellar, and she told me all these swamp bugs were getting into where she stores her wine.
Did you ever hear from Harper again?
I did. I didn't reply to her email right away. I'm a busy gal, so Harper sent me another email asking me again to help her with pests, and this was over an entire month later, so it seemed to me like she was having a lot of difficulty getting rid of the bugs. And she said to me,
Objection, Your Honor,
just
to
can't
speculation, as it seemed to be difficult to get rid of the bugs on Harper's end. That would be speculating into the situation and into the situation of Peony Estates at the time.
If I may, Your Honor.
I agree. I'm going to sustain and strike that part of the testimony.
Yes, Your Honor, I'll move on. Now, what else did she say?
Harper quite literally said to me, I just can't get these dang pests from my cellar, and it's really making me worry.
Was that the last of it?
No. On May 12th, 2019, Harper told me she had failed a health inspection, and for shame, the grape gods frown upon her.
What happened?
It turns out Harper had been storing pesticides in her bottling area and in her cellar, which is a major no-no in the wine business. She told me that her employees never wanted to haul the pesticides out to where they're supposed to be stored, and asked me how I get my employees to store pesticides safely all the time.
Were you concerned by that?
Of course I was. Pesticide is a poison, and it should be kept far from the wine at all times. As a winemaker, you're responsible for making sure you produce a safe product. It's your duty to the grapes and to the people. And keeping pesticides that close to wine is not only dangerous, but also illegal.
Thank you, Your Honor. No further questions.
May I proceed?
Yes, you may. Go ahead.
Ms. Francasio, you've owned your winery, Rosie and Pedro, for about 25 years now, is that correct?
That is correct.
And in 2012, you hired Harper Martini as a cellar hand?
I did, yes. Harper was one of my little cellar rats.
Yeah, absolutely. And one of her main responsibilities was to handle pests, that's right?
That is correct.
And this involved the usage of pesticides, right?
Yes.
Now, the cellar went under pesticide spraying about 5 or so times during Harper's employment, correct?
It did.
And during that time, you never had a health code violation?
No, I did not.
Harper always conducted proper pesticide usage, isn't that correct?
I'd say that Harper, along with all my other employees, did do a good job, yes.
All right. In fact, Harper impressed you so much that you promoted her to the vineyard manager. Isn't that correct?
Well, actually, 2 of my previous managers had to leave my winery, and Harper was the only one who could tell a Cabernet from a Merlot, so I had to promote her, yes.
Absolutely, because she impressed you so much. Isn't that correct?
Yes.
Now, Harper Martini was instrumental to putting Rosie and Pedro on the map. Wouldn't you say so?
Objection,
All of
Your
my
As to relevance, this doesn't go towards any knowledge or experience that Harper Martini has with dealing with pesticide use and proper storage of pesticides. This is merely talking about the wine business as a whole, which is not relevant to today's case, as what we are discussing is whether or not Peony Estates and Harper Martini were negligent in their use of pesticides.
What was the question? I'm sorry.
I asked, Your Honor, I asked Ms. Francasio if Harper Martini was instrumental to putting Rosie and Pedro on the map, if I may proffer.
Go ahead.
Ms. Francasio will go on to testify about her professional and personal relationship with Harper Martini, and I will go to show that, or Ms. Francasio will go to show that the loss of Harper Martini was really harmful to her business. It goes to bias, and therefore it is relevant in today's case to show Ms. Francasio's bias against Harper Martini and Peony Estates as a whole.
Plaintiff, would you like to be heard any further?
Very briefly, this question does not elicit any sort of bias from Danny Francasio, nor does it go towards how Harper left Danny's winery and then started her own. This is a completely separate line of questioning.
This question may not itself, but it sounds like it's foundational and is going to be leading to that point. So overrule the objection and allow it to continue.
Yes, Your Honor.
Now, Ms. Francasio, Harper Martini was instrumental to putting Rosie and Pedro on the map, correct?
I give credit to myself and all of my dedicated employees for putting my winery on the map. And Harper was one of those employees, so yes.
And during this time, you and Harper grew quite close, is that correct?
Yes.
And Harper and her daughter Casey even became like family to you.
Yes, that is correct.
But that all changed in 2015, didn't it?
Could you clarify what you mean by that?
Well, Harper left your winery to start her own, isn't that right?
She did, yes, and I have nothing but respect for Harper and her business.
Well, Harper tried to give you her 2 weeks notice at that time, didn't she?
She did, yes.
And you didn't allow her to do that, did you?
I didn't allow her to put in her notice?
No, you didn't. You told her to never come back to the winery, isn't that right?
I allowed Harper to quit her job and to open her own winery.
Well, you felt betrayed at that time, didn't you?
I did feel a bit betrayed that one of my own employees would open her own winery, but I still respected her.
Absolutely. Now, I'd like to talk to you a little bit about Casey Soto and Genesis Petrillo, if that's all right. Now,
Yes, that's all right.
All right. Now, in 2018, Casey and Genesis came to tell you they were getting married, didn't they?
They did, and I was so excited for them.
Absolutely, especially because they wanted to use Rosie and Pedro as their venue, isn't that right?
Yes, of course.
So you showed them all of their options for wedding plans, didn't you?
I did.
And Genesis said they would think it over and get back to you, right?
Yes, she did.
But in November of that year, you received an invitation to Casey's wedding, didn't you?
I'm sorry, could you repeat what you just said? My
Yeah,
screen froze. I didn't catch any of
you're
that.
fine.
Thank
So
you.
in November, you received an invitation to Casey's wedding, didn't you?
I did, yes.
And the wedding venue was Peony Estates, wasn't it?
It was, and I was honestly a little shocked about that, but I understood given that that was Casey's own mother's winery.
Absolutely. And Genesis told you that that was a personal decision, right? To change the venue.
Yes.
All right. Now, Harper's Winery seemed pretty successful, didn't it?
It did,
Objection,
yes.
Your Honor. Lack of personal knowledge.
If I may respond, Your Honor.
You may.
The witness will go on to testify, if I may proffer,
Go ahead.
that from the opening of Peony Estates in 2015, Danny Francasio's winery had seen a significant decrease in profits, which Penny Francasio attributed to the opening of Peony Estates.
All right, plaintiff, would you like to be heard?
Yes, Your Honor. If this is the line of questioning that opposing counsel is trying to elicit, then I would ask that she start with that foundation before jumping ahead and asking my witness if she finds Peony Estates to be successful. Furthermore, she still does not have the personal knowledge. She can testify to what happened to her own business, but she still can't testify to what happened to Peony Estates in the characterization of how well Peony Estates does.
Given that it's cross, I'll overrule and allow the attorney to order the questions the way that that she would like. And if there is an issue regarding knowledge, then the witness can handle that issue.
Yes, Your Honor.
All right.
All right, now, Ms. Francasio, Harper's Winery seemed pretty successful, didn't it?
It seemed like she had business, yes.
Well, in fact, your wine sales have been down ever since Harper opened her winery. Isn't that true?
See, going from being the only winery in an area to having a competitor obviously means, yes, I'd see a bit of a decline in business.
Absolutely, so much so that you yourself had to take a 25% pay cut, isn't that right?
I did. I wanted to ensure that all my employees continued to be paid fairly for their hard work, and if that meant hurting myself a little bit, I was willing to do it.
Well, except for the fact that you even laid off plenty of employees in that process, didn't you?
I had to keep my winery operating smoothly and cost effectively.
Absolutely. Now, Harper Martin did reach out to you for help a couple times, isn't that right?
She did send me emails about how she was experiencing a pest infestation in her cellar.
And so you decided to contact investigative journalist Lonnie Paris, correct?
Yes, I did. I wanted the truth to get out about Peony Estates.
And that truth would be their health issues and pest issues, correct?
Yes.
But Lonnie Paris isn't a health inspector, is he?
Lonnie Perez is an investigative journalist and the best in the business.
So you never contacted a health inspector to inspect Peony Estates?
See, in the winery business, health inspectors regularly conduct inspections. Therefore, I did not see it necessary to contact a health inspector.
But isn't it true that you knew how to file an anonymous report to a health inspector?
Yes, that is true.
And you didn't do so, right? You contacted an investigative journalist.
Yes, that is what I did.
All right. And I just want to make it clear today that if Harper's Winery was shut down, that would probably be good for Rosie and Pedro's business, correct?
Yes, that is correct. However, I'm not here to hurt Harper. I'm here to tell you what I know.
And you're voluntarily testifying on behalf of the plaintiff today, correct?
I'm sorry, could you repeat that?
You are voluntarily testifying on behalf of the plaintiff today?
Yes, I am.
No further questions, Your Honor.
Thank you. Are there any further questions for Ms. Francasio from the plaintiff?
No, Your Honor.
Okay. Thank you for your testimony, ma'am. You may step down, and the plaintiff, you may call your third witness whenever you are ready.
Yes, Your Honor. At this time, the plaintiff calls Mr. Riley Adkins O'Keefe to the stand.
Okay, Mr. Adkins O'Keefe, you may begin questioning him whenever you're ready, Mr. Arnold.
Great. Can you please spell your name for the court? Or say your name for the court, excuse me, spelling the last for the record.
Yes, my name's Riley Adkins O'Keefe, O-K-E-E-F-E.
And what do you do for a living, Mr. O'Keefe?
I work for the Rapid River County Department of Health and Environmental Services, or DHES. I ensure proper health and safety regulations are followed in places of business.
And can you tell us a little bit more about your role at the DHES?
Yes, I'm a certified health and safety inspector and an official designee of the FDA, the Food and Drug Administration, for whom I've conducted more than 170 winery inspections since 2010.
And why are you here today, Mr. O'Keefe?
Well, between 2015 and 2019, I conducted 4 separate investigations into Peony Estates. I'm here to share my findings about the health and safety conditions followed or disregarded by the estate.
Now, Mr. O'Keefe, you said you conducted several inspections. Let's take those one by one. When did you conduct your first inspection?
My first investigation was on May 11th, 2015.
And can you tell us a little bit more about this?
Sure. I initially found no signs of violations of any codes in the vineyards, production facilities, storage spaces, or bottling areas. However, I did find some issues with Peony's use of pesticides.
And can you tell us a little bit about these issues?
Well, due to Peony's close proximity to the swamp, they have an increased level of pests. Therefore, their pesticide usage was above average. Chemical pesticides are dangerous, so they must be handled carefully.
Now, what was the problem specifically with Peony's storage of pesticides in 2015?
Well, I discovered that their storage shed was too close to the wine production and winery kitchen area. For safety reasons, we require that you store pesticides at least 50 feet away from any production or storage area.
Now, when was your next inspection, Mr. O'Keefe?
My next inspection took place on December 7th, 2018. I received an anonymous letter about a potential increase in pesticide usage at Peony, and therefore, as a health and safety inspector, it was my solemn duty to investigate this tip-off.
And did you find anything of note during your inspection?
I did not find any specific violations, but I did gain insight into the process Peony uses for storing and using pesticides.
And can you explain a little bit about that?
Yeah, I learned that the storage shed for the pesticides was located at the far end of the vineyard, which I believed to be a potential problem because it was so far away that I had some doubts about it. That's why I spoke to the Peony staff to learn more.
And what did you learn from the staff?
Well, I learned that my fears weren't unfounded. I talked to Austin Lewis to learn about the grape growing and pesticide storage process, and I talked to him about my concerns about the shed's distance.
Now, you said that your fears weren't unfounded. Can you explain what you mean by that?
What I mean was, Martini told me that the staff was practicing all the necessary safety precaution measures, but it was clear from my conversation with Lewis that the employees did not always follow the process and would frequently store the pesticides closer to the wine cellar for convenience.
And so what did you do about this?
Well, okay, technically it's not a illegal practice. They didn't violate any codes, but I did believe this was potentially unsafe. So I decided to return within an year's time for an unscheduled inspection.
And when did you return?
About 5 months later, I returned to
Objection, Your Honor. I believe that the timekeeper is up.
Okay, do both teams have a timer?
Yes.
Okay, and is there an agreement that time is up?
Yes.
Okay, how much longer do you have on the direct?
Just about 4 or 5 questions, Your Honor. We can sum it up in one last question for time's sake, if you allow us.
I will allow that over the objection of the defense, and the objection's noted. But given that this is an invitational, I'm going to allow the one last sum up question.
Yes, Your Honor. So, Mr. O'Keefe, can you just walk us through your final inspection at Peony Estates, please?
Yes. Well, during my final investigation, I discovered several major health code violations, ranging from containers of pesticides being present in an open bottling facility to a bottle of Cara sitting on a shelf close to where the pesticide cans were. And even on my insistence to move the bottles, I heard no news to whether it was moved or not. And also I learned that the employees did not know how to safely handle pesticides and did not know about the importance of keeping them away from wine production and processing areas.
Thank you, Your Honor. Because of our time constraints, we have no further questions. I just ask that the witnesses be ready for cross-examination. Thank you.
No problem. Defense, whenever you're ready, you may commence with cross-examination.
All right, thank you, Your Honor. Mr. O'Keefe, you take your job very seriously, correct?
I definitely do.
The purpose of your job is to protect the health and the safety of the public, right?
Yes, and that's why I do unscheduled inspections around the clock. I make sure I will never let a violation pass by me.
All right, Mr. O'Keefe. In some situations, you could probably say that you could even save somebody's life, correct?
Yes,
So if you suspect that something is wrong, you'd take action, right?
I would, although the FDA chains me with procedures.
So just to clarify, as a health inspector, you never shut down Peony Estates, correct?
Well, as I just stated, I'd love to. I wanted to shut down Peony Estates, but the FDA has procedures. I can't just do what I want. I have to go by the book.
Okay, Mr. O'Keefe. Now, did you ever put any of that in your any of your findings or your statements
What specific statements are you talking
that
about?
you wanted to shut them down?
I did mention that I did want them to be shut down, but that I had to follow a procedure.
In your statement, you wrote that you wanted to shut down Peony Estates. Is that your testimony today?
I believe I thought about it, but I might not have written it in my affidavit.
So you will agree that it was never put anywhere in your inspections, correct?
No, it was not.
All right, thank you. And now, on your inspection in 2018, you found the storage facility inconvenient for pesticides, right?
Yes, I did.
And you stated it could potentially create a health violation, correct?
Yes, it could potentially create a health violation.
But you never had it moved.
Well, I informed them that they could move it. I gave them steps on what they could do.
Right, but in the same inspection, you tested the wine cellars, correct?
I did.
And you sent all those samples to the DHES laboratory.
Yes.
And for all those samples, all those samples came back and contained acceptable levels of contaminants, correct?
Yes, but at least the wines I tested, I only tested 20% of them.
But you did test them, correct?
Yes, I did.
And for your final inspection, you went to the production area at Peony Estates.
I did.
And you saw a bottle of wine sitting on the shelf, yes?
Yes, Cara. I had a problem with that bottle of wine since the start.
All right, and on that shelf, you noticed that it was across from pesticides, correct?
Yes.
You said it was improper storage of pesticides on the shelf next to the bottle of the Cara wine, correct?
Yes, it's a potential health and safety risk.
But you didn't confiscate the bottle.
Well, I can't, it's not in my power to confiscate the bottle. I talked to an employee to move it.
All right, and you still didn't shut down the winery, correct?
As I said earlier, there is procedure that I need to follow. I don't have the power to shut it down. I put them on a probationary basis.
Did you put that in the report that you wrote?
Yeah, I put it that that they were functioning on a probationary basis for 45 days.
Right, for the bottle of wine, correct?
Yes.
Now, you asked the owner, Miss Martini, about the bottle of wine, correct?
I apologize. Could you repeat the question?
You asked Miss Martini about that bottle of wine, correct?
Yes, I did.
And Harper said that she threw it away when you said it was a hazard, right?
Yes, but I doubted the answer because the bottle.
Your Honor, objection to hearsay to the statements of Harper Martini. While Harper Martini is the plaintiff's party opponent and therefore is an exception to hearsay, the Harper Martini is not a party opponent for the defense, and therefore her own statements do, pursuant to case law, America's Best Cookie versus International House of Waffle, those statements by Harper Martini are hearsay.
Okay, I understand. Defense, would you like to be heard?
Yes, I would, Your Honor. I would like to say that this was a conversation directly between Mr. O'Keefe and Miss Martini about the bottle of wine that is in question and is why we're in court today.
Has this conversation been discussed? Has there been testimony about this conversation already on the record?
I don't believe so.
Okay, so this is the first time that we're bringing it up?
I believe so, yes, Your Honor.
Okay, so then do you have an exemption or an exception to the hearsay objection then?
Yes, Your Honor, I do. Under the hearsay objection, I would like to point out that this was a direct conversation between Mr. O'Keefe and Ms. Martini. That was put in his reports that we are also looking at today. And so I'm just reflecting back to the reports that he wrote.
Okay, I understand that. Unfortunately, that's not an exception to hearsay. So do you have a rule number that you'd like me to refer to? If you need time to confer, to refer to a document, then you can do that.
It doesn't, Your Honor, I would like to point under the exceptions of hearsay that it does affect the listener and affects his inspections, his opinions about the winery and what he has been stating in court. I believe that is under Rule 803, exceptions to the rule against hearsay. Under, let's see.
Well, if you're just saying that it's being offered to show the effect, then you're saying it's not hearsay. So,
I'm sorry, Your Honor. I just found it on here. It's 801 under the statement means a person's oral assertion, written assertion, or nonverbal conduct if the person intended it to be an assertion.
Right. Okay, plaintiff, if there's a limiting instruction placed that it's just for the effect on the listener, will that suffice, or do you believe that that's not accurate?
Could I actually ask that opposing counsel please reread the statement?
The question that was
the question and
yes, yeah, the question including the statement from Martini.
Okay.
Absolutely. It was about the question was if he asked the owner, Miss Martini, about the bottle of wine and what happened with that.
Well, there was a statement that you read from the defendant, right? In your question?
No, I did not. I referenced it. I didn't read it.
Okay.
Then, Your Honor, yeah, as I suppose that's all right with the limiting instruction, as long as it's being used on the affected listener, as long as that if I feel that it goes beyond the bounds of that like special limitation that I'm able to re-object.
Of course. So we'll overrule the objection at this time, but you're free to re-raise it if they go beyond the bounds.
Yes, Your Honor.
All right.
All right, now, Mr. O'Keefe, to turn you back to my question, Miss Harper said that she threw out the bottle when you said it was a hazard, correct?
That's what she said.
Objection, Your Honor. This is the statement that I was referring to earlier. I believe that they are using this for the truth of the matter asserted to show that Harper Martini did indeed throw that bottle of wine into the garbage.
Okay, so what effect are you going to be eliciting once you get the answer to this question, defense?
Your Honor, I'm trying to elicit that he never saw the bottle be thrown away. He just said that he wanted it thrown away because it was a hazard. So he can't state in court today whether or not it was thrown away. He also didn't take the bottle. He ended up leaving that. So I'm trying to assert that he did not follow through with his job, like he was saying a lot in his direct earlier.
So he didn't investigate to see whether or not that statement was true.
Yes, Your Honor. He, as an inspector, determines the violations and is the perception of the winery. It goes to the heart of his testimony.
Okay, I understand. I'm going to overrule the objection and allow you to go forward.
Yes, Your Honor.
Now, Mr. O'Keefe, when you were talking with Miss Martini, she said that she threw out the bottle when you said it was a hazard, correct?
That's what she said, but the bottle was in the exact same place that I'd seen it last time. It was too much of a...
But you couldn't tell whether or not it was the same bottle, correct? You didn't have any knowledge.
I did not, but it was in the exact same place. That's so coincidental.
And right, you didn't take the bottle of wine, correct?
Well, as I said earlier, I'd like to have that power, but I don't. The FDA doesn't give me that much power.
Yes, and so you can't say for certain that the Cara bottle of wine you saw had been contaminated in a yes or a no answer. Please.
No, I cannot, but it was in close proximity to pesticide canisters.
So you don't know any of the actions that the winery took to remedy the violations, correct?
No.
And Miss Martini could have thrown the bottle away and you wouldn't have known, correct?
I would not, but once again, there was too many coincidences happening at that winery, I tell you.
And you didn't know that because you didn't follow up, correct?
I apologize. Could you clear up the question?
So I asked the question of if Miss Martini, Your Honor, I think that was time, but may I finish the question? All right, thank you. Now, Miss Martini could have thrown away the bottle and you wouldn't have known because you didn't follow up on that inspection, correct?
I did not.
All right, thank you. No further questions.
All right. The witness is excused. Thank you for your testimony. And with that, does the plaintiff rest?
Yes, Your Honor. With that, the plaintiff rests our case in chief. Just a small note. Do we know what time all loss is?
I don't think that they're going to be enforcing it that strictly. So if you want 5 minutes, if you want more than 5 minutes, whatever you guys want.
We are pretty amendable. Honestly, it's up to your preference, Your Honor.
All right, let's come back in 10, 12:55.
Great.
All right, thanks.
Thank you.
Okay, we'll get started in like 1 minute. Unless everybody's back right now and is ready to proceed.
The defense is back and ready to proceed, Your Honor.
Okay, what about plaintiff?
Yes, Your Honor. Yeah, we are ready to proceed as well.
Okay, so then we can, are the other scoring judges ready to come back and proceed?
I'm here.
Okay. All right. So then let's go ahead and let's proceed. Looks like seems like everybody's here and ready to go.
Yes, Your Honor. The defense calls Dr. Remington Cannon to the stand.
Okay. All right, defense, you may proceed whenever you're ready.
Please introduce yourself to the jury.
Hello, my name is Dr. Remington Cannon.
Dr. Cannon, what do you do for a living?
Well, currently I work as an associate consultant for Gardner Consulting Incorporated, where I assess and analyze the actions and conclusions that are made by medical professionals that are being used in court cases.
Can you tell us a little about your educational background?
Sure. I received my degree in chemistry from Ohio State, and then I graduated from Harvard's medical school with an emphasis in toxicology.
And what did you do after leaving med school?
First, I worked to become the chief toxicologist at Massachusetts General Hospital in Boston before taking a faculty position at Midlands Medical School, where I taught courses on toxicology.
Dr. Cannon, why are you here today?
Well, I was hired to assess the findings and conclusions of Dr. Kwan in the death of Genesis Petrillo.
How did you begin your analysis?
Well, I began by reviewing the materials that were made available to me about the case before I started to analyze Dr. Kwan's conclusions.
What materials did you review in preparation for trial today?
So I had access to Dr. Kwan's official report on the morning of Genesis Petrillo's death, the affidavit of Angel Rodriguez, Genesis Petrillo's toxicology and lab test reports, Genesis Petrillo's death certificate, the analytical report of Genesis Petrillo's Cara wine bottle, and an alcohol impairment chart.
Dr. Cannon, did you review an autopsy of Genesis Petrillo?
No, strangely, I don't believe that Dr. Kwan ordered an autopsy, so there was actually no report for me to review at all.
And what method did you follow to analyze Dr. Kwan's findings?
I began to compare Dr. Kwan's method of examination with standard emergency medical protocols, and then analyzed the accuracy of Dr. Kwan's conclusions. Emergency rooms can be extremely hectic, so it's important to really pay attention to the calls and decisions that are made in such a fast-paced environment.
Let's talk about what Dr. Kwan found. What were his conclusions?
Dr. Kwan found that Genesis Petrillo most likely died from an organophosphate pesticide poisoning, and he also concluded that this poison most likely came from a bottle of wine that was ingested on June 7th. I, unfortunately, found that it was not that simple.
Dr. Cannon, what do you mean?
In this case, there are facts that are consistent with organophosphate poisoning through a bottle of wine. However, there are several alternatives that simply cannot be ruled out, some of which—
Objection, Your Honor, if I may.
What are your grounds?
According to Rule 702, testimony by an expert witness, 702D, defense counsel must establish that the expert has reliably applied the principles and methods to the fact of this case. This has not been established, as it was never asked if the methods that she used were applied reliably.
Okay, defense, would you like to be heard?
Yes, Your Honor. So Dr. Cannon explained the methods and materials that she reviewed in today's case, and she also told us that the methods that she used were commonly used by people in her field.
Your Honor,
Yes.
that satisfies 702B and C. However, 702D must also be established, and that was never established as it was never asked if those methods that she used were then applied reliably.
Okay, I'll agree, and I think that foundation can be laid. So I'll sustain the objection for now and ask defense to lay that additional foundation.
Yes, Your Honor.
Yes, Your Honor. Dr. Kwan, how did you apply the methods in today's case?
Oh, I applied them just as I was taught in medical school and as how I've learned to do it through my many years of experience in this field.
Let's go back to Dr. Kwan's conclusion. What was the problem with that?
Well, like I was saying earlier, there are several facts that are consistent with organophosphate poisoning through wine in this case. However, there are several alternatives that I personally am not comfortable ruling out. Some of these conclusions, it appears Dr. Kwan did not even consider.
Let's talk about what Dr. Kwan did consider. What are those diagnoses?
So Dr. Kwan considered alcohol poisoning and pesticide poisoning.
What are the diagnoses that Dr. Kwan did not consider?
So in my analysis, I found that Genesis Petrillo had potential symptoms of hepatic disease, allergic reaction, and even poisoning through some means other than the bottle of wine. In fact, I found it possible that Genesis could have experienced one or more of these medical emergencies, since I am unable to rule out any of them happening individually.
I want to discuss Dr. Kwan's examination of Genesis Petrillo. What were Genesis Petrillo's symptoms of each illness?
So I have actually prepared a presentation that will better help illustrate the symptoms that Genesis Petrillo was experiencing on the morning of her death, if I might be able to show that.
Your Honor, permission for Dr. Cannon to screen share her demonstration?
Has the plaintiff had an opportunity to review this prior to trial?
Yes, we have, Your Honor.
Any objection to it being shared?
No, Your Honor.
Okay, then let's go ahead and do it.
So this is the differential diagnosis chart that I made for Genesis Petrillo.
Let's talk about these symptoms that Genesis Petrillo had. What were her symptoms?
Sure. So on the morning of Genesis Petrillo's death, she was experiencing nausea, stomach pain, vomiting, contracted pupils, low acetylcholinesterase levels, difficulty breathing, involuntary muscle spasms and seizures, watery eyes, impairment of motor function, sweating, all during this period of time.
And which of those symptoms correspond with each of those diagnoses?
Sure. So for alcohol poisoning, you see nausea, stomach pain, vomiting, seizures, impairment of motor function, and sweating were all symptoms that lined up with alcohol poisoning.
What about for pesticide poisoning?
So here we see every box is checked, that every symptom that Dr. Kwan noted in his report does in fact match with pesticide poisoning.
Can you tell us a little about the diagnoses that you diverge with Dr. Kwan? Allergic reaction and hepatic disease?
Sure. So for allergic reaction, the symptoms that Genesis Petrillo was experiencing include nausea, stomach pain, vomiting, difficulty breathing, and watery eyes.
Dr. Cannon, why did Dr. Kwan not rule out these diseases?
To be perfectly honest, I can't say for certain. Even if you look at hepatic disease, there are many symptoms in each of these categories that I think deserved a moment of reflection on Dr. Kwan's part. So unfortunately, I was not there, so I cannot say for certain.
Well, what data did Dr. Kwan collect?
So in my personal analysis of the case, Dr. Kwan did not run any tests or request any data to specifically rule out or prove alcohol poisoning, allergic reaction, or hepatic disease. However, a test was run to show pesticide poisoning, but to my knowledge, that is the only further piece of evidence that was collected as to what kind of medical emergency Genesis Petrillo was experiencing.
Earlier, you mentioned the possibility of Genesis experiencing multiple of these diagnoses. Can you explain that?
Sure. So, similar chart, only this time the potential medical emergencies are grouped. So here you can see how, with the potential for multiple of these incidences taking place, it really becomes very clear that there are multiple symptoms that go towards multiple illnesses that should have been reviewed.
What about the final alternative that you mentioned, poisoning through another means?
Sure. So in the stomach, there are certain enzymes and acids that break down your stomach contents, and then the stomach churns them all together in order to begin the digestion process. So because of this, it is impossible to know for sure whether the wine actually contained the organophosphate pesticide simply because they were found together in the stomach.
What is your evaluation of Dr. Kwan's analysis?
Well, in my professional opinion, there are too many unknowns and flaws in Dr. Kwan's theory to claim that Genesis Petrillo died from ingesting wine that contained an organophosphate pesticide.
What is your final conclusion in the cause of death of Genesis Petrillo?
Due to the inability to rule out any alternate causes of death, I am unable to definitively say what killed Genesis Petrillo. Due to the lack of knowledge as to Petrillo's outside health factors at the time of their death, no one, including Dr. Kwan, can say what killed Genesis Petrillo.
Thank you, Dr. Cannon. Your Honor, I have no further questions.
All right. Thank you. Plaintiff, whenever you're ready, you can begin cross-examination.
Yes, Your Honor. So, Dr. Cannon, I would like to start with your background. You work for Gardner Consulting, correct?
Yes, that is correct.
And one of Gardner's biggest clients is Detsky Roach and Rodent Killer.
Yes, that is correct. They're not my personal client, but I'm aware that they have contracts with our company.
And Detsky makes chemical pesticides, correct?
To my knowledge, yes, I believe that that is their what they produce.
Now, the CEO of Detsky knows you're involved in this case.
I'm not actually sure as whether or not the CEO of Detsky knows of my involvement. I know that my personal CEO and boss is aware of my involvement in the case. I'm not entirely sure as to what the breakdown of their relationship is, however.
Dr. Cannon, it's true that the CEO of Detsky Roach and Rodent Killer knows you are involved in this case.
I'm aware that the CEO is aware that my company is taking this case on. Yes, if that's what you mean.
But Dr. Cannon, the CEO directly told you that it is extremely important, if you want to continue to have their business, that a pesticide not be found responsible for Genesis Petrillo's death, correct?
I believe that my personal CEO told me that after finding out of my involvement in this case.
So it's your sworn testimony today that it is not the Detsky CEO, Eli Harrison, who told you this?
Oh, Eli Harrison. Yes, I'm sorry. My mistake. Yes, you are correct.
So, Dr. Cannon, the CEO of Detsky told you that if you want to keep their business, you better not find a pesticide responsible for the poisoning of Genesis Petrillo.
So this was a statement made to me. Fortunately, I was very well into my investigation in this case. I am aware that, should a certain result come from this trial, that we could lose their business. However, it's not just their business on the line, it's my medical license. And to be perfectly frank with you, I would much prefer to protect my medical license and reputation as opposed to some client or business that I am not personally affiliated with.
But Dr. Cannon, you don't want to lose Detsky as a client, do you?
It would certainly not be preferable, but I would certainly rather protect my reputation.
That's a yes, you don't want to lose them?
Yes, absolutely.
Now, I'd like to move on to your analysis of Ms. Petrillo's death. So starting with the explanation of alcohol poisoning. Now, you claim that Petrillo's BAC, blood alcohol content, could have been high enough to point to death by alcohol poisoning.
Absolutely. To be perfectly honest, we don't really know what Genesis Petrillo's peak blood alcohol concentration is.
But actually, there was a test conducted by Dr. Kwan in order to determine her BAC, correct?
Yes, that's correct. The blood alcohol concentration test was taken at 2:52 a.m. on the morning of Genesis Petrillo's death. To my knowledge, Genesis Petrillo had stopped drinking definitively at 2:42. However, there is report from Angel Rodriguez that it's possible that Genesis Petrillo stopped drinking around 11 o'clock, which means that's potentially 2 to 3 hours of no drinking activity whatsoever, where Genesis Petrillo's blood alcohol concentration could have dropped significantly. So yes, it was 0.16%. However, that was a very long time after Genesis Petrillo had stopped drinking for the night.
So Dr. Cannon, you claim it could have been high enough to cause alcohol poisoning, but you have absolutely no affirmative evidence to back that claim up, do you?
Well, I think that the problem is that actually there's no evidence to say for sure what Genesis Petrillo's peak blood alcohol concentration is.
That's a yes?
Yes, I agree wholeheartedly.
Now, Dr. Cannon, does the explanation of alcohol poisoning in any way explain the isofenfus pesticide in Petrillo's stomach contents and blood work?
No, it does not.
And finally, you yourself acknowledge that the explanation of alcohol poisoning as a cause of Petrillo's death is highly unlikely to be true.
That is correct, but I do think it's important to note that I do still think it's possible, and I cannot rule it out as a possible cause of death.
Now, you also think that it's possible that her death could have been caused by allergies, correct?
Yes, that is correct.
However, Dr. Cannon, none of the medical evidence you reviewed indicated that she suffered from allergies.
Yes, that is correct. There was no evidence of any kind of allergy in Genesis Petrillo's medical report. However, to my knowledge, Genesis Petrillo's medical work from the past 3 years isn't super solid. And also, the important thing to know about allergies is they really can develop at any point in time. So it's possible that this was a new allergy for Genesis Petrillo.
But that's a yes? You saw no evidence for this claim?
Yes, which is what makes it so scary.
Another cause you gave was that she could have suffered from hepatic disease. Now,
yes.
You reviewed her medical records, correct?
Yes, I reviewed what was made available to me.
And once again, there was no evidence of this explanation that she could have had hepatic disease.
Well, actually, I disagree with that statement. There were symptoms on the morning of Genesis Petrillo's death that goes to show hepatic disease as a potential illness that Genesis Petrillo was dealing with.
Is it your sworn testimony that you found evidence of hepatic disease?
It's my sworn statement that I saw symptoms that match up with hepatic disease. No tests were done to confirm this, but there are symptoms to say that it is possible that this is what Genesis Petrillo was experiencing.
In fact, Dr. Cannon, you actually find this explanation to be the least plausible explanation.
I think out of all 4 listed explanations, it is the least likely. However, I cannot rule it out.
Now, Dr. Cannon, the empty bottle of Cara wine tested positive for isofenfus organophosphate pesticide, correct?
Yes, I believe that is correct.
And you say there's a chance that the pesticide was consumed via a different vehicle and then mixed with the wine in the stomach, correct?
Yes, that is according to how the stomach works. It's entirely possible that it was digested in some other form and that it happened to mix in the stomach.
But that is also highly unlikely.
It is not the most likely explanation. However, I do still think it's possible. And
Dr. Cannon,
I'm sorry?
You can finish.
Okay. Once again, simply due to the lack of follow-up evidence in this case, I really can't rule any of my conclusions out.
But Dr. Cannon, it is highly unlikely in your opinion.
Unlikely, but still definitely possible.
And in fact, all the leftover food and drink tested from the night of Petrio's poisoning was negative for pesticide, correct?
So from my knowledge, the only food and drink that was tested was the food and drink remaining, which means that the food and drink that was consumed was not actually tested. So yes, there was food and drink tested. However, every single piece of food and drink was not tested.
But also, Dr. Cannon, Genesis was the only one who seemed to suffer ill effects, correct?
To my knowledge, yes. However, I don't currently work in a medical room, so I can't say for certain how many people arrived on that night with similar symptoms.
Now, Dr. Cannon, on your direct examination, you were able to testify at length on the possible explanations for Miss Petrio's death. I'd like to take my last 3 questions to ask you solely what you find to be most likely. First, you think that respiratory arrest is the most likely cause of Petrio's death? Yes.
Yes, fortunately, I do agree with Dr. Kwan in that case. There was no autopsy run, which I find extremely strange in a case like this, but from the symptoms that Dr. Kwan listed, I would agree with his final analysis.
And yes or no, Dr. Cannon, you also find that the cause of this respiratory arrest is most likely isophenphos organophosphate pesticide poisoning.
Yes, I do think that it is the most likely cause. However, with my medical license on the line, I would not feel comfortable saying, it's definite, or I'm not even sure I could go so far as to say more likely than not.
But Dr. Cannon, it is your sworn testimony that the most likely cause of respiratory arrest is pesticide poisoning.
So it's definitely the most likely, but that doesn't mean necessarily that it is even beyond 50%. Not to say that I have calculated the numerical possibility of each of these happening, but hypothetically, you could have 4 possible events. One that's 35% likely, another that's 20% likely, another that's 30% likely, another that's 15% likely. That 40%, even though it's most likely, I still would not want to say that it is definitely what happened.
And finally, Dr. Cannon, just a simple yes or no will suffice. You believe that the most likely cause of isophenphos pesticide poisoning is the wine produced by Peony Estates.
So from my limited knowledge in winemaking, it would appear as though that is the case. However, I cannot rule out any other form or means of pesticide poisoning.
Dr. Cannon, that's a yes to my question.
Absolutely, yes.
Thank you, Your Honor. No further questions.
All right, thank you, counsel. Is there any redirect for this witness?
Briefly, Your Honor.
You may.
Dr. Cannon, why are you skeptical of Dr. Kwan's conclusion?
There just isn't enough evidence to support any major conclusion. Yes, I agree that it is most likely that it was caused by pesticide. However, I don't feel comfortable making that statement definitively due to the lack of knowledge and the lack of work done to rule out other possible causes of death. Genesis Petrillo hadn't even had a basic blood panel in the past 3 years. Now, something as simple as that could rule out pretty much all of the other possibilities on my list. We just have no evidence to definitively claim one way or another what killed Genesis Petrillo.
Thank you, Dr. Cannon. Your Honor, I have no further questions.
Okay, any questions based on that redirect?
None, Your Honor.
Okay, the witness is excused. Thank you very much. All right, defense, whenever you're ready, go ahead and call your next witness.
The defense would like to call Ms. Blair Osborne to the stand.
Okay, whenever you're ready.
Please introduce yourself to the jury.
Hi, my name is Blair Osborne, and I'm the owner of Bliss by Blair Events.
And what is your business?
It's an event planning business. I plan everything from conferences, anniversaries, birthdays. Honestly, if you can think of an event, I can plan for it. But I'm mostly known for weddings.
And how long have you held your events at Peony Estates?
For 4 years. We've held 83 events there, and it's my favorite place to host events.
Why is Peony Estates your favorite place to host events?
Okay, they saved me when I was in this like real jam. I had 2 events, one had to finish, one had to start. I was running out of time, and they let me hold one of the events there. And honestly, they have such high standards. Like, how can I not hold my events there?
Why do you feel that they have higher standards?
I mean, their staff are amazing. They're super diligent and attentive to like all my clients' needs. If there's a problem, they fix it. And the clients have no idea. And it's super clean. Like, I've never seen anything that's concerning there. Like, it's great.
And where were you working behind the scenes?
Anywhere that the clients were or that employees for the event were.
What did you do?
Well, it was just like to make sure that everything was running smoothly. I want the clients to have the best event possible.
Did you ever see any pesticides anywhere at the winery while you were working?
Never. I never see pesticides while I'm there.
Have you ever been to the kitchen?
Oh, yeah, many times. I mean, you have to make sure that all the food's being prepared and that everything's going smoothly.
And was there anything out of place while you were in there or anywhere?
Oh, no. Everything was going perfectly everywhere for all the events.
And on your many walkthroughs of the winery grounds, have you ever seen anything out of place?
No, never. The winery grounds are beautiful. I love it there.
Any misplaced pesticides outside?
No, I've never seen any pesticides while I'm there.
And Miss Osborne, have you ever seen anything at Peony Estates that would make you question its cleanliness?
Never. I've hosted so many events there, and I've been there for pre-event meetings. And I mean, I've been there at least 83 times for the events, and it's always clean. If it wasn't, I wouldn't hold my events there.
Objection, Your Honor. Character evidence. They're using a past form of speculation to prove action per Rule 404.
Okay, I'll hear from the defense.
Your Honor, it isn't character evidence. Miss Osborne was at Peony Estates multiple times, hosted many events. There's been plenty of foundation laid, and we have seen that she has seen her own experiences, and therefore she can attest to whether or not she saw that the events she was holding at Peony Estates were clean.
Right, but she's trying to, my understanding is you're trying to connect these past events to the current event in question and trying to say that because of how it was in the past, it was more likely to be a certain way in this case. Is that not what you're trying to do?
Yes, Your Honor, it is. But I'd also like to point out that Miss Osborne was hosting events around the time that all of this was happening. She was also involved with the wedding. Therefore, she's able to say whether or not it was clean during that time.
Okay. I'll hear from the plaintiff again. Why is this impermissible? If they're on the defense, are they not allowed to offer a character witness to testify to a specific character trait that's relevant?
Your Honor, their testimony is saying that because they were clean in the past, that somehow makes it clean now. That past evidence doesn't prove anything about the status quo nature of Peony Estates.
Okay. Defense, are you allowed to, I mean, let me ask you this just point blank. Are you allowed to offer character evidence?
It goes to show, I believe it you can, because there is no action or conformity therein, and it shows the habit of the Peony Estates.
Okay, so you're offering this as habit testimony under 406?
Yes, Your Honor.
Okay, I'll hear from the plaintiff.
Your Honor, per Rule 404, it's very explicit that character evidence is not welcome. Because they were clean in the past, that does not definitively make it clean now.
Okay. You may, defense.
I also do want to add that because in pointing back to the what I was saying earlier, that Miss Osborne was at the wedding there at the time and experienced a lot of the similar cleanliness issues. So she's able to attest to how clean it was during that time.
Well, let me ask you this. Was there a pretrial form that was submitted regarding the offering of character evidence by each side?
Your Honor, I don't believe so.
I don't believe so. I'm just pointing to her perception of the winery itself.
Okay. All right. Given the proximity between when she was there and when the incident happened, I'll go ahead and let that testimony stand, and it can be considered for whatever weight that the jury wants to give it.
And Your Honor, we have no further questions.
Okay. Just give me 1 second. All right, whenever the plaintiff's ready, you can go ahead and cross-examine.
Yes, Your Honor. So, Ms. Osborne, you've held over 60 events at Peony Estates, is that correct?
That is correct.
So you have very close ties with Peony Estates.
Yeah, I definitely do.
And you consider your relationship with Miss Martini to be like family?
Yes, I have a professional yet warm relationship with Peony Estates.
All right, and you were hired for your services for Casey and Genesis's wedding, correct?
Yes, I was.
And in doing so, Miss Martini hired you to plan for this particular event.
Yes, she did.
And in doing so, she promised you an extra 15%.
Yes, she promised me that. I mean, yeah, she did.
For you to keep your services discreet?
Yes, she did.
Okay. And your relationship with Peony Estates has been profitable for you, yes?
I mean, it's going to be profitable with wherever I host my events. I don't know if I could say that that's with Peony Estates particularly.
But your historical relationship with Peony Estates has been profitable for you.
It's been profitable because that's where my clients have decided to host their events.
All right. So a shutdown of Peony Estates would have a negative effect on your business, correct?
No, I can host my events anywhere.
But so a shutdown of Peony Estates would not have a negative effect on your business?
I can host my events wherever I need to.
How many events have you hosted there in the past?
I've hosted 83 events there.
So losing Peony Estates as a client would definitely hurt business.
Objection,
No.
Your Honor, to asked and answered.
Your Honor, Your Honor, I have not received a definitive answer to this question. I have not received a definitive yes or no.
If I may.
Go ahead.
Miss Osborne has responded saying that it wouldn't because she could easily host her events anywhere because it is an event planner. And I believe that she's sufficiently answered the question of the plaintiff.
Yeah, she's given a pretty definitive answer. It might not be the answer that the plaintiff wants. If you believe that this is inconsistent, then plaintiff is free to impeach the witness. But I think you've received your answer.
Okay. I'll just continue then.
Okay.
Okay. So, Miss Osborne, you agree that planning this wedding was chaos, yes?
I mean, as much as planning any wedding, it's gonna be dramatic. There's conflicting opinions and everyone wants the wedding to be how they want it to be.
But it was the worst professional experience of your life.
I mean, it was a hard wedding to plan. There were a lot of strong opinions and there was a lot that was happening.
But the theme, in your words, was crying and fighting.
I mean, yeah, I mean, people got upset when they didn't get their way and there was some fighting over what kind of flowers to pick, what kind of invitations.
Objection, Your Honor, to relevance.
Your Honor, oh, my apologies.
Go ahead.
Your Honor, Miss Osborne's intentions in business with Peony Estates is necessary to showing and indicating bias, and bias is always relevant.
Okay. How is this showing bias?
because it shows that their connection with Peony Estates, despite the negative attitudes and implications that this wedding had, they still decided to go through with it despite the extra 15%, despite all the conflicts.
Okay. Defense, do you have anything else you want to be heard on?
I would just like to say that he's asked similar questions the past 3 times of the and I just am not able to see the relevance of these questions.
Okay. I'll overrule at this point, but let's ask a couple questions and then move on.
Okay.
Your Honor, I would just like the crossing attorney to know that he has a minute left for this cross and next cross, just so he's aware.
Oh, wow.
Okay.
Really? Okay.
All right. I'll wrap this up pretty quickly. May I proceed? Okay. In the middle of so in May, you met with Miss Martini to discuss decor options, correct?
Yeah, we discussed flowers and invitations as such.
And in the middle of the meeting, Mr. Martini received a phone call.
I believe that they did, yes.
And in that conversation, they said, no, keep the bottle of Cara where it is.
Yes, I think that's what they said.
Then, no, don't have them move the pesticides.
Objection, Your Honor, to hearsay?
Okay. Would you like to be heard? No, plaintiff, I'm sorry. I should have specified.
Yes, Your Honor. Pursuant to Rule 801 D2D, this is an exception to hearsay because the statement was made by the party's agent while Miss Osborne was contracted by Miss Martini.
Okay, defense, would you like to be heard as to that?
From what I'm understanding with the question that he asked, it was about something that she overheard, a conversation she may or may not overheard, and I believe it was a phone call. She cannot really say to whether or not she heard something when it was over a phone call, and I would consider that hearsay. She was contracted by them.
Is the statement, have you laid do you believe that the foundation has been laid that this witness can identify the person who made the statement?
No, Your Honor, I don't think so. Miss Osborne is not an agent of Peony Estates. She was contracted, but she is not a Peony employee.
Oh, okay. We're talking about Miss Osborne's statement.
Or overhearing the statement.
Or overhearing a statement. Okay. Well, the statement, the declarant has to be the agent, not the person overhearing it. So who's the declarant? Who's the person making the statement? Plaintiff.
Your Honor, the person making this statement was Miss Martini. These statements are not hearsay because they were contracted, or because Miss Martini contracted Miss Osborne, and per 801 D2D, those are exceptions to hearsay.
I don't think that even matters. As long as it's Martini that's making the statement, then it sounds like that's party opponent. Am I right?
Can you or can you repeat that one more time? My apologies.
If the declarant is Martini, Martini is your party opponent, correct?
Correct.
Okay, then I'm going to overrule the objection.
Okay. All right. No further questions, Your Honor.
Oh, did you get your answer?
My apologies. Okay, so they said, no, keep the bottle of Cara wine where it is.
Yes, that's what I heard.
Then, no, don't have them move the pesticide.
Yes, I also heard that.
Okay, no further questions, Your Honor.
Is there any redirect?
No, Your Honor, I just asked that my witness be able to step down.
Okay, thank you, Ms. Osborne, for your testimony. And can we get a check of how much time there is for a cross-examination of the third witness?
17 seconds, Your Honor.
Okay, plaintiff, what's your estimated amount of time that you would normally spend on this cross-examination?
Normally several minutes. However, I mean,
what's several minutes?
And I will obviously have to work around the time constraint.
I'm just trying to figure out how much time I'm going to give you.
I can do a minute. I can do a minute. That would be adequate. 30 seconds to a minute.
Okay, I'll give you 2. If you think that a minute's enough, then we'll go with 2.
Okay.
Your Honor, I'm sorry. Pursuant to the competition rules, this is not allowed. The defense and the plaintiff both have to declare their times in captain's meetings and are required by the rules of the competition to stay within those time limits.
And I understand that, and I do appreciate that, but the central canon of the American Mock Trial Association's education, and pursuant to that, I think it's better education. I think educational purposes are served better by allowing the students to have an adequate opportunity to compete in all aspects, and I don't think 17 seconds is going to serve that. So while I do agree that you are 100% correct, and to the extent that we are violating certain competition rules, I will take the brunt for that. But I do think that for purposes of education, that this is the right and fair thing to do. Okay.
Yes, Your Honor.
Thank you, Your Honor.
Your Honor, the defense calls Austin Lewis to the stand.
Okay. Defense, you can proceed whenever you're ready.
Please introduce yourself to the jury.
My name is Austin Lewis, and I was born and raised in Rapid River Valley.
And can you tell us a little bit about yourself, Mr. Lewis?
Well, I work as a lead winemaker following in my mother's footsteps, and I work at a beautiful Midlands winery, Peony Estates.
And how did you get the job at Peony Estates?
Well, I was offered the job when I worked at a different winery, Rosie and Pedro, and I was offered it by my friend Harper Martini. I kind of accepted the job on the spot. I was really excited to get out under my old boss's thumb, and I left with Harper and a group of other workers to start a new winery.
And how exactly did you meet Miss Martini?
Well, I met Harper Martini when I was working at Rosie and Pedro. We quickly became inseparable. So when she offered me the position to work as a lead winemaker with her, I accepted on the spot, obviously.
And what was your role at Peony Estates?
Well, as lead winemaker, I would oversee growth, fermentation, really anything that involved the actual wine I dealt with. I was kind of the artist. Harper handled more of the business, and I was kind of the hands-on guy.
All right, and can you tell us a little bit about the beginning of Peony Estates? How did that go?
Well, Peony Estates bordered the Salove Swamp, so while the soil was great, we had a little bit of a bug problem.
Well, what methods did you try to use to get rid of the pests at Peony?
Well, we initially tried organic methods, but they weren't working and they were costing too much money. So in 2015, we switched to chemical pesticides.
Well, can you discuss the proper process for pesticide usage at a winery?
Well, whenever we had to spray an area of the winery, specifically inside, we would empty the area of wine or wine precursors, shut down or remove any equipment. And if it couldn't be moved, we would wrap the equipment. We would spray it, leave it untouched for 2 days, move everything back in, and after spraying, obviously, wash our hands and change into fresh clothes.
All right, now who exactly sprays for pesticides at Peony Estates?
Well, I do and the employees do. Harper put me in charge of the training, so I train our employees on the annual pesticide spraying, or I annually train them, and throughout the year, I'll organize the sprayings. Only a qualified employee or myself is allowed to spray. And if it's not me spraying, I'm supervising.
All right, now how'd you go about training employees for pesticide spraying?
Every year, since October 2015, I made sure they were very familiar with the proper procedures for spraying and handling the pesticides.
Objection, Your Honor, to speculation as to whether or not these employees were actually properly prepared and understood the proper procedure when handling pesticides.
Okay, I understand. Defense, would you like to be heard?
Yes, Your Honor. Austin Lewis was the sole individual in charge of training and overseeing all spraying procedures, and to ensure that his employees followed those procedures. If I may proffer, we'll go over some of those procedures and how they were followed. And therefore, I don't think this would be speculation, as he is the one who would be aware of what the training consisted of and how it was applied.
Okay.
May I respond, Your Honor?
Plaintiff?
Yes, Your Honor. While this witness is able to testify that he did indeed give these seminars and that he did indeed maybe train them. He's not able to delve into the mindset of the employees by saying that they did indeed understand them and that they actually comprehended or listened to him even. While he is able to testify on these things that he taught them, he cannot testify that they fully understood or fully followed the proper guidelines.
Okay. I'm going to agree with you in part. I agree that he can't testify to what their state of mind was, but he can testify to what he observed. And I think that's all defense is doing. Am I right?
Yes, Your Honor.
Okay. So then based on that, I'm going to overrule.
Yes, Your Honor.
Now, what was the purpose of these safety measures, Mr. Lewis?
Well, safety. I had to make sure that there was no chance that any of these chemical pesticides would contaminate our wine.
And how effective did you find your pest control to be after the use of chemical pesticides and training of the employees?
Well, since Peony Estate's existence, we have had to regularly spray pesticides over the course of 4 years, and we've never had an incident of one of our bottles be contaminated.
All right, now I'd like to talk to you about the 2019 wine produced by Peony Estates. Could you please tell the jury what that wine was?
Yes, we're a boutique winery, so we come out with signature wines each year, and in 2019 it was Cara.
All right, now as the employee at Peony in charge of pesticide usage, how do you know no bottles of wine were contaminated?
Well, I'm the lead winemaker at Peony Estates, and I am one of my closest friends is the owner. So if there was ever an incident in which one of our bottles was contaminated and resulted in somebody getting sick, I would have heard about it, or Harper would have heard about it.
Now, prior to the incident with Genesis Trio, was there any other incidents involving wine and pesticide poisoning?
Yes, there was one incident in which one of our employees left a glass of wine out during a spraying.
And what happened at that time?
Well, the employee drank a sip of that wine and became seriously ill and almost passed away.
And what did you do to make sure that that would never happen again?
Well, the employee directly violated our protocols by having a glass of wine out during a spraying of pesticides. So although they got ill and we dealt with that, the issue kind of solved itself. It taught all the employees not to leave their personal glasses of wine out during the pesticide sprayings.
Objection, Your Honor, again to speculation as to what this taught the employees. If I may continue, Your Honor.
No, I understand your objection. Defense, would you like to be heard?
Yes, Your Honor, this is just going to show the effect of, it's not speculation to the mindsets of the individuals, but as this incident never occurred again, and Austin Lewis will go on to testify that he retrained the employees after this incident, it's not speculation as to.
I think it is speculation as to why it didn't happen again. So to that extent, I am going to sustain and strike the testimony about them learning whatever he believes that they learned.
Yes, Your Honor. Now, Mr. Lewis, did an incident like this ever occur again?
No, not after I retrained our employees. It did not.
All right, no further questions at this time, Your Honor.
All right, plaintiff, whenever you're ready, go ahead.
Yes, Your Honor. Mr. Lewis, I'm going to keep this brief. You began using chemical pesticides at Peony Estates in 2018, right?
No, we began using chemical pesticides in October 2015.
Oh, yes, but you started using them on the crops themselves in 2018. My apologies.
Right.
Okay. And you only used one brand of pesticide?
Yes, particularly the Bug Off brand.
Right. And Bug Off, the main chemical ingredient is isofenphos?
Yes, sir.
Now, you wanted to be a little bit more careful about the chemical pesticide uses, especially regarding the crops, right?
Initially, yes, I wanted to, I was a little bit hesitant to use pesticides on our crops, yeah.
And Harper seemed annoyed that you wanted to be more careful about the pesticide use?
That's kind of speculation that Harper seemed annoyed. I don't believe that counsel has laid the proper ground for that statement.
May I respond, Your Honor?
Go ahead.
Your Honor, this witness on direct examination, I believe actually referred to Harper Martinez as one of his best friends. So the foundation that he would understand when she is annoyed is laid. Also, I asked if she seemed annoyed, which is simply asking Mr. Lewis to testify on his rationally based perception of Harper's mood and attitude about his wanting to be more careful about pesticide use.
Okay, we'll limit the testimony to what his rationally based perception was, not whether or not the witness was actually annoyed. So overruled.
Yes, Your Honor.
So Mr. Lewis, again, Harper seemed annoyed that you wanted to be more careful about pesticide use.
She seemed a little bit annoyed, but she listened to me.
Well, she actually said that a little bit of pesticides was not a big deal, right?
Yes, she said that at one point.
She also said that everything has pesticide in it nowadays and no one ever died from it. That's a direct quote, right?
Yeah.
And you actually wanted to retrain your employees on proper storage and handling procedures after one of your failed inspections?
Which particular inspection are you referring to?
The one in May, from May 2019, I believe.
Yes.
So you wanted to retrain your employees on proper storage and handling procedures?
I did.
But Harper actually forbid you from retraining your employees, right?
Well, she forbade me from additional training. We still did the annual training. I mean, that was required, but she did say that it would be too costly to have additional training organized. So she forbade me from organizing additional training. Yes.
From retraining, right?
Yes,
I'm
from retraining.
Their 2-second grace period. Or two.
Okay.
Yeah.
All right.
That's understandable. Thank you, Your Honor.
All right, time is up. No further questions. Is there any redirect?
No, Your Honor, I just ask that Mr. Lewis be allowed to step down.
Yes, he may. Thank you very much. Okay, that's third witness from the defense. Defense, do you rest?
Yes, Your Honor, the defense rests and is ready to proceed to closing arguments.
Plaintiff?
Yes, we are also ready to continue to closing arguments at this time.
Okay, so no, do either of the scoring judges request a recess before closing arguments?
Your Honor, I apologize. Yeah, this is tournament staff. We're actually running a little short on time, so if we can just go immediately to closing arguments, otherwise we have to penalize both teams.
Okay, all right, well then that's exactly what we'll do. All right, plaintiff, whenever you're ready, go ahead and commence with closing arguments.
Yes, Your Honor. May it please the court, opposing counsel, members of the jury. With a series of FDA violations within the year of the accident, it is no surprise that something went wrong. And indeed, something did go wrong, because on June 7th, Genesis Petrillo consumed a Peony Estates bottle of wine that had been poisoned by pesticides. As a result, she died just the day before her wedding. To hold Peony Estates responsible, the plaintiff holds the burden of proof to show that Peony Estates is liable for negligence per se by a preponderance of the evidence. Now, let's break down that burden. What preponderance of the evidence means is that we must prove that it is more likely than not that Peony Estates was negligent and that this negligence caused the harm suffered by Ms. Petrillo. If at the end of trial today, you find that the scales have just barely tipped in our favor, then the plaintiff has met our burden and you must find the defendant guilty of negligence per se. Members of the jury, we have met our burden today. We have met that burden because we showed you that on July 12th, 2018, Peony Estates failed an FDA inspection by Inspector Riley Adkins O'Keefe, who found that they had been storing and using pesticides in a way that did not abide by safe health procedures. On May 8th, 2019, just a month before the wedding, Peony Estates had 3 more health code violations. They were still storing pesticides in the bottling facility. Their employees weren't aware of how to safely handle pesticides. And there was a single bottle of 2019 Cara wine sitting on a shelf right next to pesticide canisters. On May 30th, 2019, that bottle of 2019 Cara wine was still sitting on a shelf in the bottling area right next to where pesticides had been previously stored. And on June 7th, 2019, despite the FDA violations. Harper Martini gifted that same bottle of Cara 2019 wine to Genesis Petrillo. Genesis Petrillo drank that wine, and at 9:27 a.m. on the morning of her wedding, she was pronounced dead due to pesticide poisoning from contaminated wine. Members of the jury, this timeline shows 4 separate instances of negligent conduct by P&E Estates. Conduct that was proven to you through all 3 witnesses the plaintiff called today. First, we called Lonnie Paris. Lonnie Paris conducted an in-depth investigation into P&E Estates, where he saw pesticide canisters in the bottling area and even an empty pesticide container next to the Cara bottle of wine. Furthermore, he found a memo from head winemaker at P&E Estates, Austin Lewis, who you also heard from today, where Austin said, quote, "We need each and every one of you to prepare the entirety of P&E Estates for an imminent pesticide spraying. We need to do this quickly and cheaply. Nothing else matters," end quote. Nothing matters to P&E Estates except spraying pesticides in a manner that is cheap and fast. It does not matter to them that chemical pesticides are a safety hazard. It does not matter to them that chemical pesticides are poisonous. It doesn't matter to them that lives are at stake. And as a result, Genesis Petrillo suffered the consequences. Danny Francasio showed you that Harper Martini lacked the knowledge of how to safely deal with pesticides. Ms. Francasio was told P&E Estates were violating the health code because their employees refused to properly store pesticides. Harper Martini told Danny Francasio that even she herself was worried about P&E Estates' inability to
Do we have a freeze up?
I believe, yeah, we have a freeze up.
Okay. So timer, obviously pause it until we get connection back.
Okay.
Thank you.
manage pests.
Okay.
However, they are not foolproof. Negligent behavior falls through the cracks and mistakes are made. But there are consequences. And those consequences occur here in court. Oh, wait. The second element of negligence per se requires that the plaintiff proves the harm suffered by Genesis was directly and proximately caused by pesticide poisoning. This was clearly established as Ms. Petrillo's death certificate explicitly states that her death was caused by pesticide poisoning. Furthermore, Paris uncovered several reports that showed there was both pesticides in Petrillo's stomach contents and blood work, and within the wine she consumed. The plaintiff has proven that Genesis' medical diagnosis was death from pesticide poisoning, that she indeed had pesticides in her system, and that these pesticides were also discovered within the bottle of wine she drank. Members of the jury, the plaintiff has met our burden of proof. We have shown by a preponderance of the evidence that P&E Estates, first, were negligent in their handling of pesticides, and second, that their negligence resulted in Genesis Petrillo consuming poisoned wine that ultimately led to her death. This is why I ask you to exercise your right as members of the jury and secure justice for Genesis Petrillo and her family. Find P&E Estates liable for negligence. Thank you.
Thank you, counsel. Defense, whenever you're ready, you can begin with your closing argument.
Yes, are the timekeepers ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
We now have all of the evidence in today's case. That is it. There is no more. And unfortunately, we are left with so many questions that we don't know the answer to. So it is no surprise that the plaintiff did not meet their burden today. You see, Ms. Turk came before you, and she said that Harper Martini gave the same bottle of the 2019 Cara wine to Genesis Petrillo, yet all three of their witnesses told you that they cannot be sure that it was the same bottle. See, our witnesses, and even some of the plaintiff's witnesses today, highlighted questions in the case that the plaintiff just doesn't want you to know about. At the end of the day, we don't know if the pesticides in Genesis Petrillo's system were from the Cara 2019 wine. We don't even know if Genesis Petrillo died from pesticide poisoning and why her death is tragic. It wasn't Peony Estates' fault. Nobody can say for certain why Genesis Petrillo died. And that is the real crime in today's case. Members of the jury, I want you to think to yourselves, why would Peony Estates do this? Why would the top winery in Midlands put their customers at risk, their family at risk, and risk their entire reputation they spent years building? That's an answer the plaintiff doesn't have for you today. Why? Because it just doesn't make sense. You heard from Blair Osborne that Peony Estates is a well-established business in Midlands who has hosted hundreds of weddings, receptions, conferences, you name it. Why would Peony Estates throw all that away? When they were confronted with pesticide problems, they corrected them. They worked at it. You heard the plaintiff's own witness, Lonnie Paris, that he found a memo where Austin Lewis was set on correcting their problems. And he was. Austin Lewis told you how he organized trainings and sprayings for the winery. It just doesn't make sense. And the plaintiff's evidence in today's case doesn't give you any answers because it's just not true. Let's talk about the plaintiff's claim. They brought forth a charge of negligence per se against Peony Estates, which they had to prove by a preponderance of the evidence, or more likely than not. They had to prove that it was more likely than not that Peony Estates failed to properly store and place pesticides and restrictions on pesticides, and that alleged conduct resulted in the death of Ms. Petrillo. Members of the jury, the plaintiff did not come close to proving their case today because the evidence just doesn't add up. There are too many questions and not enough answers. The plaintiff had to prove to you that Peony Estates violated Midlands Section 12100 by failing to place adequate restrictions and precautions in place to protect against any contamination. And they did. Nothing else matters in Peony Estates besides their reputation and their employees. The employees of Peony Estates knew and were prepared to properly use pesticides. You heard the plaintiff's own witness, Lonnie Paris, who tore through the winery property for 2 years, testified today that a whole month before the wedding, Peony Estates' kitchen was spotless, and the 2019 Cara wine bottle he saw by the pesticides was not there. Lonnie Paris and no one else can be sure that the bottle was the same one that Harper Martini gave Genesis Petrillo. You heard from Austin Lewis that Peony Estates held trainings for all the workers on pesticides. They had to prove this negligence was more likely than not, and they failed to do so. The plaintiff also had to prove to you that Genesis Petrillo's death resulted from the negligence of Peony Estates. But what they don't want you to know is that there were questions unanswered. Questions that Dr. Kwan, the treating physician of Genesis Petrillo, did not even consider. There is a reason why the plaintiff did not call Dr. Kwan today. You heard how Dr. Kwan failed to run a proper blood alcohol test, an allergic reaction test, and even a basic blood work panel on Genesis Petrillo. Remember what Dr. Cannon told you today. She said that Dr. Kwan did not gather all the necessary data to make an accurate diagnosis of Ms. Petrillo. Did Ms. Petrillo even die of pesticide poisoning? We cannot know because Dr. Kwan only ran one pesticide test and neglected to do basic blood work on Genesis Petrillo that would have yielded data on Mr. Petrillo's blood alcohol level, liver, histamine levels, and almost every other possible cause of death. Dr. Cannon told you that because of this, there are multiple other possibilities as to the cause of Genesis Petrillo's death. Alcohol poisoning, hepatic disease, an allergic reaction from the very antidote Dr. Kwan administered, and even that the pesticide entered Genesis Petrillo was not even from the Cara wine. Genesis Petrillo's death was tragic. And it is terrible how the plaintiff doesn't have the proper answers and evidence to give her justice. The best they could do was present two witnesses with something to gain from today's trial and a health inspector that was eager to shut down Peony Estates but couldn't. We are left with too many questions and not enough answers. Peony Estates didn't act negligently. They were a well-respected business adapting to an environmental problem. They put in the work and took care of their business. They cared about their employees and their reputation. It makes no sense why they would throw it away. And it makes no sense to consider the plaintiff's evidence sufficient. Find Peony Estates not liable. Thank you.
Thank you, defense. Does plaintiff have time for rebuttal?
Yes, Your Honor. I believe I have 1 minute and 7 seconds for rebuttal.
Okay. Whenever you want to proceed, you can go ahead.
Yes, Your Honor. Now, opposing counsel came up here and asked you to think about why Peony Estates would be negligent. But members of the jury, I would like to remind you that why is not a factor in today's case. Today, we are trying negligence per se. No motive or intent or question of why is required. What you must determine is what. What happened that day and what happened at Peony Estates. And the plaintiff has met our burden by showing you that both their own two witnesses, Austin and Blair, testified to failure of Peony Estates to follow health code procedures regarding the pesticide. They had their own expert witness come up to the stand and say that she, in fact, finds it most likely that Genesis died from pesticide poisoning. And that is why I ask you to find the defendant liable for negligence per se.
Okay, thank you. Let's just give, I think the scoring judges have to just take a few minutes to finish up.
All right, my ballot is submitted.
Mine is as well.
All right, thank you, guys. So I guess we'll go ahead and do the traditional introductions and general comments, and then I guess it's not really possible to do individual comments privately, so I guess after general comments, we'll be pretty much wrapped up. So I'll defer to the scoring judges first here.
Cool. Hi guys, my name is Brandon. I am not an attorney. I'm a management consultant in Dallas, but I did 4 years of AMTA mock trial. I do a little coaching now, got to compete at nationals, was an attorney and a witness. So love mock trial and love everything you guys get to do. Congratulations on making it through round 2. For some of you, this is probably your first online competition. And I did fill out on individual comments, so you will get those. But comments more generally, first of all, I think it's crucial in this new environment that you use demos, not just for experts anymore like we used to in person, but I think for every single witness, even in the opening statements and in the closing arguments, you should also think about using demonstrative aids. A really good reference for that, if you got to view any of the One Last Time competition footage, AMTA's posted those online. You can even just watch the championship video. They use demos, both the plaintiff and the defense, throughout the entirety of trial. And there's a really good reason for doing that. To be honest, it's really easy to get bored watching just in-person competition through this virtual format. Even if you have a great character, it's a lot harder for a judge to perceive things like changes in pitch and changes in speed whenever you're speaking over this online format. Also, I know there's also the temptation to have things memorized. So doing things to catch a judge's attention and to make it less boring will definitely help you out. And demonstrative aids are a great way to do that. I think they're a must through almost every witness if you can. You don't even have to use an exhibit in the case. You can build things like timelines and things like that just to keep our attention. Also, in opening statements and throughout the entirety of cases in chiefs, I don't think I heard any theme statements, which is something that I've always gotten comments on my teams. And judges, we really like hearing that, especially when it's used multiple times in each statement and argument, as well as throughout a case in chief through the witnesses and through the cross examinations. And then just lastly, look excited. You know, we're looking through this virtual format, and you have an opportunity that you need to capitalize on with being able to present yourself better than another team whenever it just comes to things like having energy. You don't want to look boring because it's already a different environment. We're not surrounded by people. So you really need to be able to look exciting. Just some things that I saw during the online competition. I saw someone ask a judge just right from the get-go in pre-trial, see people with smiles on their faces. You can ask the judge, or whenever you introduce yourself, you can say like, good morning from Central Time and from wherever you may be joining us, or just something interesting. And always make sure to be happy looking and have fun. And that'll really be able to add to your credibility and show that you're energetic and really invested in what you're doing.
It's my turn now. All right.
Go right ahead, yeah.
Yep. Hi. My name is Megan. I'm a 3L here at Wake Law. I guess not here since we're not in person, but I'm a 3L at Wake Law. I'm the captain of the AAJ trial team here. I did a mock trial in undergrad for about 3 years, both an attorney and a witness. So I have been through this on both sides. I'm still doing it, and I feel all of y'all's pain on the online competition format. We're currently going through the same thing at the law school level. So I feel your pain on that, and we all are working to try and figure out the best possible way to do a online Zoom trial. And I understand that it's super difficult. So props to you guys for trucking through it and figuring it out. I also filled out individual comments, so hopefully you will be getting those. I just had some general comments. First and foremost, just when you're making objections, you know, I think as a whole, you guys did a good job making the objections. That's always the first step, is to make the objection. But I think the next step is to work on tightening them up. You know, when you make an objection, and it's really hard on this Zoom thing because you have to unmute yourself, but just be assertive and just say, you know, objection, Your Honor, under it's hearsay, relevance, under 403, whatever the grounds are. And then I would recommend waiting for the judge to address you. Sometimes we have a tendency to get excited and like truck ahead and be like, here's my reasoning, but just wait for the judge to acknowledge you. Then you can, and then same thing. If you feel strongly about it, like you really want to be heard, maybe say, you know, objection, Your Honor, relevance, may I be heard? But always wait to be recognized by the judge. Same thing for when you're responding. Wait for the judge to recognize you for a response. And just same thing with your objection arguments. Just get to try to work on tightening them up, getting to the point quicker. Direct examinations. I think, you know, this early in the competition season, it's really easy to sound scripted because you're probably working really hard on what you're going to say. But try to work on making it sound more conversational, making it sound like a conversation, especially for witnesses. Sometimes, especially when something's super memorized, it can sound stilted and awkward. A recommendation is try to put something in your words and something that you would normally say as a person. You know, if it's something that you would actually feel comfortable saying, a turn of phrase or a metaphor you use in everyday life, it's going to sound more natural coming out of your mouth. You know, just try to work on not sounding like you're reading a script. Try to get off your notes. And if you're already memorized, try to work on making it sound more conversational. For attorneys, you can work on looping, on, you know, and for a lot of attorneys, when you're directing, get engaged. A lot of you sounded like you were reading off, just you were going off the questions without actually sounding invested in what your witness was saying. So really like make it like a conversation. If you act like you're interested in what your witness is saying, the judges and people who are watching will be more interested in what your witness is saying. If you make it sound like, oh yeah, that's a really interesting point that you're making. When you win an objection, re-ask the question. If the other side bothered enough to object to it, obviously they don't want it in and you won. So re-ask it, let everyone hear it again. And if you have a good witness, they're gonna not only restate it, they're going to emphasize it and draw it out and say it louder and be like, look at this thing that they wanted to keep out, I'm going to say it again. So definitely re-ask your question when you win an objection. And just generally on openings, you guys did a great job of getting out the important facts, laying out the basic facts we needed to know, but maybe work a little bit more on telling a story. This is a really interesting fact pattern with a really compelling story, and you could do some really great imagery with this case about, you know, this gorgeous vineyard, and, you know, this should be such a happy place where someone should be getting married right now, but instead she's dead. You know, you could do some really great storytelling in your openings, and also in your closing, telling that story. And something that I think even I still fall into with my closings now, that we can always work on is when you're doing your closings, don't just restate facts and restate evidence. Don't just like walk through the evidence, argue it. You know, don't just tell us you did a good job of restating. These are the important points of the trial, but tell us why those points are important. Why do they matter? String them together, take those points, connect them, and argue them. That's all I had. I hope that was helpful.
Okay. Hi there. So my name is Stephen Borello. I'm a public defender actually out here in Los Angeles, and have worked with the UCLA team for about 12 years. Right now, my job, I was doing trials for a number of years. I started misdemeanors and then was in felonies for the past several. And right now my job, taking a little break from that, I actually train, help train some of the misdemeanor lawyers that come through our office. Right now, this is such an early tournament. I mean, October 17th is, I know UCLA, the state schools, just barely started school. So, the fact that you guys are ready, putting the case together in this short a period of time is pretty remarkable. So you should be, very proud of yourselves just to be ready at such an early stage in the year. I haven't read the case, didn't know anything about the case going into it, but I, was able to piece together, and I think you both, it's a testament to each side that I was able to follow the trial from beginning to end. Didn't have any issues following the stories. I do think that you can simplify the opening statements, kind of like Megan was saying, and just make it more visual. Tell me the story, give me the scene, put some more emotion into it, because ultimately you kind of have to almost work in overdrive under this format, because it is so much more difficult to convey emotion, convey subtleties when you're in this online format. If you're in person, you can see subtleties, you can see changes in speech patterns and so forth, but it's much more difficult online. I know that in our real life, trials were really suspended for quite some time and have been just barely coming back. And one of the things that the courts were trying to do for us was they wanted us to do virtual trials where the jury was basically like this on Zoom, watching the trial. And my office, public defender's office, was very much against that, because the ability to see a witness and judge their credibility is so much more compromised when you're not there in the same room, 10 to 15 to 20 feet away, being able to look that person in the face and see what they look like. So in terms of ways that I think that you do have to kind of reimagine mock trial in this format, because there are so many differences. I think the first decision that you have to make as a team is whether you're going to stand or sit for many of the different parts of the thing. I noticed for the plaintiff, for example, you had the opening standing up and the closing sitting down. I think you have to make a decision one way or the other. Are you going to sit or are you going to stand, and make it consistent? Whereas the defense made it very clear, we're going to sit. And I think that sitting, I think there's pros and cons for each. I think sitting, you do seem much more calm and it's conversational. The con is, of course, that you don't have the ability to be as flashy and to use hand gestures and use movement, and have sort of those look at me moments. But I think it's trial and error. That's what the invitational season is for, is to, figure these things out. And by the time you reach the competitions that matter, the regionals and the orcs competitions, then you're really going to have an idea of what you're going to be doing with this new format. So I think the suggestion to watch the One Last Time tournament trials is a great idea. When I first started mock trial many, many years ago, the way I learned was watching final rounds and seeing what the best of the best did in the normal, in-person format. So I think the similar way of learning how to do it in this new format is how do the best of the best do it in this new format. If that means using more demonstratives, making it more visual, then go ahead and do that. I'm sure that all of you have people that are really good with graphics and designs. And if you don't, then recruit somebody who is to put together some really swank demonstratives for you, so that you can really engage the jury. So my general comments are just that, on objections, tighten them up. I was pretty liberal in terms of giving people a chance to go back and forth, but sometimes the most powerful way to end an objection battle is to say, I've got nothing I need to say anymore, Your Honor. You don't say it exactly in that way, but you say submitted. because it means you're conveying the notion that I think I've got this one. Because sometimes if you're just repeating yourself, you're going to get some judges who are just like, why is he or she doing that? They're just repeating themselves, and it's an opportunity for you to look confident and for you to look like you're ready to be declared the winner. It's an opportunity wasted. So so definitely, if you're having these objection battles, whether it be character or whether it be hearsay, something that is going to take a little bit more than just a simple one time back and forth, be ready with the rules of evidence. Give me rule numbers, give me citations, give me case law. You did a pretty good job. You cited case law a few times. But give me stuff to base my rulings on, because once you give me a case, once you give me a rule number, you're giving me, as a judge, you're giving me authority for me to be able to make that decision. So I know you guys have gone twice today. So if you have any further questions, I'm more than happy to answer anything. Just so it's clear though, in terms of the whole timing issue, if this had been orcs or if this had been regionals, I would absolutely not have given any additional time. The rules would have been strictly complied with, but for an invitational, I was willing to be a little bit more liberal. So just that was one last thing I wanted to sort of give as an explanation for that. I think we had two very experienced, very learned scoring judges who I think were more than able to make the adjustments in the scoring, notwithstanding me sort of going a little outside the rules there. So yeah, if you have any questions, I'm more than happy to stick around for a few minutes. Otherwise, good luck tomorrow and good luck for the rest of the season.
Thank you. Thank you.
Thank you all.
Yeah, I have a question.
Go for it.
Yeah, it's like not Noah and Anant. You guys can go get in our Zoom. I'll be there in a minute. Same with you, Ella and David. Yeah, no, it's not super important. I just there's one objection battle that I was just curious about. The one about when we were talking about Harper Martini's statements and like about throwing the bottle of wine in the trash or whatever. I don't know if you remember that.
Okay.
Yeah, and I said it was hearsay, that her statements were hearsay, and that they were trying to prove that it was indeed thrown in the trash. You overruled it. I mean, it seemed like, I don't know, it seemed like I just kind of wanted to pick your mind on that a little bit.
Oh, it was offered for effect on the listener or whatever of the inspector.
Yeah. And you just thought that was a more compelling argument. I don't know. I mean, that's fine. I'm genuinely just curious because I just.
It could have gone either way. I got to be honest. Yeah, okay. that one could have gone either way. I wasn't necessarily persuaded by either side on that one. So I pretty much just wanted to see where the line of questioning went. So honestly, that was why I overruled it.
Yeah. Okay. Yeah. No worries. I just felt
Yeah. Of course.
All right. Thank you so much. Have a great rest of your evening.
You too.
Bye.